may I be permitted to mention one extreme urgent matter. But 7th is the last date for admission in the MD course. But I am a sponsored candidate by the state government. But I qualified in the admission test. But the state government is not issuing release order in my favor. For that reason, my provisional admission was done. But the institution has said unless you submit the release order from your employer, the admission will be cancelled. 7th is the last date for submitting the release order. Any date before 6th, because the institution in the Pondicherry, but I have to submit the document before.
You are employed here?
Yeah, as a medical officer. I am sponsored by the state government for pursuing MD course. The release order is not.
All right, 4th it will appear.
I'm extremely good.
May I have your lordship's leave to mention? Your lordship, I'm praying for leave to apply to draw up and complete an order passed by your lordship on the 13th of July. It was an exercise by the erstwhile advocate within 7 days, hence I'm praying for
Original side matter?
your lordship, original side. Great for your lordship.
Actually, may I permitted to mention, lordship, praying for leave to draw and completion of the order dated 28 April 2026 passed by your lordship.
April?
Lordship, this is the delay, lordship, kindly allow us.
Babu, give original side.
Lordship, may I be permitted to mention
Drop and complete.
extremely urgent matter, your lordship. I am a PG. I'm pursuing PG in SSKM hospital, your lordship. Lordship, by an order dated 22nd January by of the division of this honorable court, an inquiry was held with regard to validity of my admission under the in-service quota. Inquiry was held. Recent orders passed. No infirmity found. However, in the month of May, another memo was issued with regard to the same adjudication. Now, the urgency is that, lordship, on 27th of July, the University of Health Science has published a notice calling upon all the students to submit their research proposals. Lordship, I am under suspension currently.
How suspension? Even after no infirmity was found, you are still under suspension?
Yes, your lordship.
So what is to be done now?
Lordship, within 15th of August, I have to file the submit the research proposal. Otherwise, my entire academic session will go in vain, your lordship.
All right, 5th it will appear. Where is the matter?
Monthly list of July 1819.
List of July.
1819.
So today is not the date. On 5th, Wednesday, urgent motion.
Grateful.
Serve notice upon your other side. Everybody should be present.
Grateful.
May I be permitted to mention those 3 Axis Bank debt matters which my lord had taken up yesterday, whereby my lord had allowed Axis Bank clarification application. My lord, I am in the process. I've been instructed to file a leave to appeal. I have already applied for the certified copy. My lord, you may kindly send the files in the department so that.
Like last time.
Yes. My lord, may I be permitted to mention?
Keep the originals with you and give.
May I give the number, my lord?
My lord, may I be permitted to mention? My lord, item number 79 of to-do list. My lord, this is a transfer matter. Petitioner is a cancer patient. My lord, chemo is continuing. My lord, petitioner facing more than 80 kilometer travel to school. My lord, fixed any day. My lord.
Which item?
Item number 79. My lord. Of to-do list.
আজকে ট্রান্সফার তো হবে না The monthly list will be published. The matter will come. All right, keep an eye. I'll fix up a date for taking up transfer matters. On that date, you please mention.
My lord, may I be permitted to mention one matter? My lord, the petitioner is suffering due to lack of terminal benefits of the deceased since 2021. The petitioner is in severe financial.
I want to know the merits of the matter. Where is your matter?
My lord, for inclusion.
Today is not the date.
For application for restoration.
No, sorry.
That's your original side assignment.
What is to be done? When was it assigned?
29.
This month? 29th? Then it will appear.
Your lordship, I'm praying for leave.
Papers have not come.
May I please, your lordship? I have an urgency.
Yes,
Your Lordship, I am praying for a leave for a matter in respect in which the examination is to be held on 3rd of this August.
which examination?
It's a Jumur course under Arsha College affiliated to Sidhu Kanu Birsha University, Your Lordship.
Uh-huh.
And examination is to be conducted in 3rd of August. More than dozens of students have not been provided the admit card. Many of them had not been even able to even register themselves for the exam. All of them have successfully cleared the semester one examinations, Your Lordship.
Does any education go on in that university or the college? Nothing.
Your
These are
Lordship,
all sham universities and colleges.
Your Lordship, they have successfully completed the semester one.
Dozens of students. It may be one or two, but when you say dozens of students, it means it goes to show that nothing is going on over there. Why will the university not want the students to be sent up to the examination if everything is all right?
Your Lordship, we have sent the representations, and Your Lordship, kindly, 3rd is the examination date for all.
Third is the examination day. Today is the 31st.
Your
When
Lordship,
can the matter be? What were you all doing so long?
Your Lordship,
Nothing doing.
Your Lordship, kindly allow.
What to allow? Where to allow? What to allow? When to allow? Where is the time? You have to understand.
Your Lordship, I bow down, Your Lordship. The students will be
Yes,
affected because of this.
nobody is a student. You file it in the department, give the number, it will appear
Lordship,
on Monday.
today the item number is 126, and yesterday it has been also mentioned, but I have an urgency to keep this matter in any day under the urgency matter, under the urgency heading. Because the school authority did not give the permission to admit this petitioner in B.Ed course, and the B.Ed
Listen, Monday command list will be published. Please mention. Yes, call the list. Uh-huh. কি হয়েছিল? CPM assigned. Let me hear. Yes.
Contempt will be issued.
Why?
Yes, my lord, this matter has been neglected. My lord, I have filed a contempt petition before your lordship already, and I pray for the issue, the issuance of contempt. I pray for the issuance of contempt rule, and to and the contemner is Manish Sharma, and two others. Contempt will be issued, maybe issued, and they are not they are not at all carrying for the orders. The order passed by the legislature are not making payment at all.
Did you get a copy of the contempt?
Yes, my lord.
My lord, as far as the PPO, my lord, let me mobile is silent.
They
As far as
are
the
not.
PPO, let me speak. As far as the PPO 25/3/2023, his salary, his pension would be 5386. But as far as the record statement of account, he is getting 5989.
Extra?
Extra 3 rupees extra.
So are you all taking steps to recover?
No, my lord, we have not taken. We have been. I haven't taken. Is the
Take your seat. Take your seat. Take your breath. Take your breath.
It's the information we're giving to the.
Just wait.
My lord, kindly, they have issued a payment authority, revised pension payment authority for pre-2006 pensioners with effect from 1st
অনিমেষ বাবু,
January
অনিমেষ
2006.
বাবু, মাইকটা ঠিক করে দিন তো।
They have already granted. They have already granted a pension up to 5,986. That is the pension to be added with the normal pension. So it is after 10 years the pension is revised. Revision is made. and this revision delayed for some their own administrative act.
But right now you are getting pension, isn't it? Revised
No, no,
pension?
pension should be added after a 10 years revision is made, and that pension has been fixed further on 5,986.
That you are
And
getting?
that should be added to this pension. The present pension, it is a revision to held after every after 10 years, and normal pension is continuous, and the normal pension this should be added. It is the revision is made after.
Previously, how much did you get?
Yes, my lord,
Previously,
this
how
should be added
much?
with that pension?
Previously, how much did you get?
Yes, my lord.
Previously, how much did you get? Where is your daughter?
No,
Where is your daughter?
daughter is not coming.
Why?
They are not. Only she assists. And my lord, I know my case very well, my lord. And this revision is made every after 10 years. And normal pension and the relief, relief is made twice per year. That is
You did you get a
normal
copy of the
pension I am
content?
getting.
No.
Normal pension.
Yes, I have
am
got. They have
getting
done a contempt against the
52,000.
bank. Against the bank here, he has done a contempt. But since we are giving the pension, I don't know how we have done it.
Did you get a copy of the
Yes,
contempt?
yes, we have.
All right.
My lord,
You come up with a report. I do not. Are you the contemptor? No.
No, yes, I am the contemptor. Contemptor is the bank.
You are the bank.
Yes, I am the bank.
All right.
I am also for the bank,
Contemptor
also for the instant railway also. I am.
contemptor to explain
All
it.
right. You file a report,
Pension should-
compliance report that you have complied the court's order. All right.
Okay, my lord.
How soon? 2 weeks?
No, 2 weeks. No, after 2 weeks, I will not be done. I know 3 weeks because from 12 to 17, I will not be here. After 17th.
My lord,
Yes.
আমরা একটা রিপোর্ট দেবো আপনাকে যে আপনি পাচ্ছেন না পাচ্ছেন।
Do not try to reason out with him.
no,
I can't understand. But even the bank has decided to give him a letter that he wants 25 lakhs. How is 25 lakhs he is wanting? Bank will give him a letter and to break up the amount of 25. If the bank thinks this amount he should get, bank will give to him. Bank has issued a letter to him. He has not received that letter.
area is for 20 years.
The bank will give you the money.
The area.
The bank will give you the money. Do not just wait. All right. The bank will give you the money. Please come here.
Bank is given normal pension. This should be added with that pension.
The petitioner has filed an application
This
for
amount should
contempt
be added.
alleging
Yes, sir.
violation of the direction passed in the order dated 27th April 2026. Stop.
Contempt will be issued.
Learned advocate representing the contemnor submits upon instruction that the order passed by the court has been complied with. Stop paragraph. The contemnors are directed to file an affidavit of compliance. Stop. Now, file a jagah be prepare and circulate an affidavit of compliance by 19th August. Release the matter on 21st of August.
I'm deeply obliged.
Would you like to take this back? Take it because I do not want to
আমাকে
keep
ওটা
it.
দিন, আমার কাছে নেই আর একটা কপি আমার কাছে একটা রিপোর্ট দেবো আমরা কোর্টকে যে আপনাকে আমরা টাকা দিচ্ছি না দিচ্ছি।
টাকা দিচ্ছি না দিচ্ছি কি বলবো?
আরে ব্যাংকও আপনাকে চিঠি দেবে।
You will be representing all the contemnors, is
Yes,
it?
I am representing all the contemptors.
Entirely different issue, my lord.
All right, next.
I'm deeply obliged.
Yes, item 2.
My lord, I'm for the petitioner. The matter has been fixed today for extension of the interim order, which is set to expire today itself.
Yes.
Yes, my lord, I am for the college authority. I have no objection to his extension, but only issue is, my lord, I have filed a CAN application 2 regarding part Z. But whenever my lord takes application, my lord,
Whenever that is different. Please come. The interim audit that is subsisting in the matter is extended till 20th of November 2026 or until further order, whichever is earlier. Liberty to mention the matter for hearing.
We are grateful.
Lordship,
Next.
Lordship, may I seek an indulgence? Lordship will not relegate this matter to the monthly list. Lordship,
I have given you liberty to mention. I have not.
the matter on
Madam,
when my lord
makes it-
take application, but probably Thursday my lord take application. My lord, kindly-
Yes, what is the urgency?
No,
No,
urgency
the-
is
the-
not the teacher is not functioning in the college, but due to this interim order, she is enjoying all the benefits.
My lord, she has not been receiving her salary for the last 4 months.
So it is his problem as well. So my lord, kindly hear
Well,
it out, because one post,
The matter,
she is occupying one post, not rendering any job there, my lord.
my lord, if I may,
Not cooperating.
the matter has been,
Investigations against this teacher.
Pradeep, liberty to mention, you delete that, you fix it on the 13th of August. It's a Thursday.
grateful.
Yes, next.
May it please your lordship, Malala, I am for the petitioner. Malala, re-NEET examination. Malala, publication of 3 different OMR sheet and different, my lord, evaluation.
In respect of one
Evaluation.
candidate,
One candidate.
3
Upsa-
evaluations.
Upsa Ganguly, 3 evaluation. 555, 215, then 281. Your lordship, let my learned friend submit from the NEET. How first 555.
Show me.
That is page P3, page 116. Koi re? 116.
555.
116, 555.
Yes.
Then, my lord, kindly come to page 118. 118.
215.
215. Then, my lord, kindly come to 123. Page 123.
One, two, three is a letter.
Representation. No. 116.
One,
My
two,
lord, 555.
one,
Then
two,
118. Then 122. 122.
281.
Yes, my lord. This is my case, my lord. You'll also kindly consider it.
All right.
I made a representation. My lord, this is my factual. I'm submitting all these things, my lord. Every service and in every service.
Yes, what is the matter?
Lordship, it's not correct. Lord, and they have, my lord, forced, my lord, the OMR sheet.
Forged.
Is that correct?
Forged.
OMR sheet? Yes. How is it possible? I can.
Now, let him submit affidavit alleging that I'm forging it.
This is.
Let him submit affidavit
No. Kindly.
on record.
I will.
Yes, give.
The calculation.
Sir,
Oh, it is possible.
118টা 2005
Kindly. My letter told page 118.
118.
This is of 2025. Kindly see.
This is not 26.
Then again, I'm telling you, he was trying, my lord. Not only that, I compared this thing with the booklet. What I mean, kindly see how they have marked. They have marked all unanswered, my lord, questions shaded in the forged one. This is a very serious matter. My learned friend is pretending.
It should be investigated. It should be investigated.
Tell me 118.
My lord,
It's a 2025 score sheet you have annexed and say it's different.
And one more thing, my lord will kindly my lord will kindly come to paragraph 5 of the petition. Paragraph 5. They have annexed copies of booklet because there are 4 booklet codes, your lordship note. OMR sheet
Yes, sir.
and answer key.
Uh-huh.
This is at starting from page 85, 86. Then kindly, my lord, take the booklet. I can demonstrate that they have marked, they have shaded. My lord, My lord, I'll demonstrate. Before that, I will show your lordship how this 116, 115, showing that this is a OMR sheet.
This is not the OMR.
This is a 2025.
25 OMR.
Yes. Kindly see the date. The date is 26, but this is a last year. Roll number she had attempted last year also. Then
রোল নাম্বারটার সঙ্গে ম্যাচ করে যাবে
roll number, kindly see the roll number of
118
Yes, page 115 is not the roll number, is not your roll number.
I'll come back, my lord. I'll come back, my lord. I will
What
come
you will
back.
come back?
Obviously, I'll
Steps
talk
will
with.
be taken against you for
Yes, obviously,
forgery.
it should be investigated. If my client instruction is this, then your lordship kindly, I'll come back. Your lordship kindly, I'll
Just
take
wait.
instruction from my client.
takes the booklet.
Yes,
Kindly
page
86.
86.
86. With a little time I got, I did some.
Yes.
My lord, 87.
Eight-
Kindly see.
87.
Kindly see.
Admit
Question number 2.
Yes.
He responded. The response a lot was
1.
1.
Yes.
আনসার
Kindly take my calculation sheet.
Calculation sheet.
Yes. And response 1.
Yes.
Correct answer was 4.
Yes.
And in a forged one, well, not doctored one, she has marked as 4. That I can show, well, not at page 124. 124. This cannot be, well, not be. She has shown that all questions have been.
roll number my roll number
Then kindly
26.
Your lordship kindly takes question number 6 in the booklet. That is at page, my lord,
88.
88.
Yes.
She has 86. She has her response was 1.
Yes.
But correct answer key was 3.
Yes.
But in the forged one, 124, she has marked 3 also. In fact, she has not attempted.
they're editing on this
Well, I'll take instruction. I'll come back. I'll take instruction, my lord.
No instruction. Offhand, prima facie, I can see this is absolutely what your client has done is not proper. If the candidate thinks that she'll be able to steal a march over the authority and the court, then it is highly improper.
Obviously, my lord.
Please come.
I'll come back. Your lordship kindly.
The petitioner participated in NEET within bracket UG 2026 examination and alleges that that her answer sheet has not been evaluated properly. Stop paragraph. Further allegation is that 3 OMR sheets, three scorecards have been issued by the authority in respect of the same candidate. Stop paragraph. Learned advocate representing NTA has raised the allegation of forgery against the petitioner. Stop. It has been submitted that the documents annexed to the writ petition are all forged and doctored. Stop. The OMR sheet, the scorecard, which the petitioner is relying upon, annexed at page 118 of the writ petition, is the scorecard for the NEET within bracket UG for the year 2025 and not for the year 2026. Stop paragraph. The OMR annexed to the writ petition are also forged. Stop paragraph. Prima facie, upon hearing the submission made on behalf of the parties on perusal of the documents annexed to the writ petition, it appears that the petitioner has indeed annexed documents of the examination conducted last year and has simply tried to confuse the authority as well as the court. Stop paragraph. Such action of the candidate is highly improper. Stop. Next. The court is not inclined to exercise jurisdiction in the matter. The writ petition fails and is hereby dismissed.
My lord, I kindly, my lord, my lord, they can take action under Public Examination Prevention of Unfair Means Act 2024. In another case, I mean, FIR has been lodged. Now, kindly indicate that this will not prevent the India will be at liberty to take appropriate action in accordance with the law, because she will be debarred for 3 years as per the.
No, but then this can happen only if something goes wrong on the date of the examination. Here,
No.
thereafter also.
Yes, I can show that it is there.
There also.
It is.
All right.
I've got the act also.
It will be open for the respondent to take steps in the matter in accordance with law. Affidavit of service written with the records.
Yesterday only, there was a big matter, my lord, the Chhattisgarh government. Identical, my lord, case, and the division bench presided over by the justice, my lord, passed an order, detailed order dealing with such matters, and it was a concocted this going on. So it should be, I mean, they did not penalize the petitioner, but it was dismissed. My lord, I got yesterday, the judgment was delivered yesterday only.
All right. You keep it as and when required, we can use it.
I'm obliged.
Yes.
This is my petition, your ladyship.
Oh, I'm for the university. I'm for the, before my announcement starts, my lord, the matter was mentioned on the ground that 2 students, they are not able to fill their form. Now, my lord, I have the instruction that absolute false statement has been made. They have filled up their form. There is no problem with regard to their.
Let him place his case. I do not know what the matter is.
Oh, yesterday it was mentioned.
You may remember, but I do not know.
There is some here for the college.
They can
only received instruction last evening that there is a matter today listed, but we are yet to receive the Vakalatnama. So if you
Kovi Guru Nobel Centenary Training College. All right, let me hear at least what he has to say.
The problem is not with regard to filling up of forms. Your ladyship may directly come to page 34 of the writ petition once. This is the notice. This is the notice which has caused trouble for me. This notice is of 25th of July 2026, whereby it has been notified the examination process for the semester 1 of the 2025 to 2027 B.Ed program. Your ladyship will see the examination form fill up is already over on 30th of July. Payment of examination fees, issuance of admit card is on 8, and thereafter theory examination starts from 5th of August 2026. I am aggrieved because the mandatory number of classes or days which are required to be attended, the classes which are required to be attended by the NCT norms is 100. That has not been provided to us by the institutions for now, could not have been provided. Why? The reason is at page number 25. This session started in 25. I got admitted in first semester in 26. This is a notice of 13th of May 2026. It says, may I read this? In compliance with order number so and so dated 12th May 2026 of Department of Higher Education, Government of West Bengal, the online admission portal will be reopened for the academic session 25-27 for filling up of the vacant seats of B.Ed self-finance colleges. Your ladyship may directly come to entry number 5. Admission in respect of colleges is 21st of May 26 and 22nd of May 26. I entered the course by way of this process.
Tell me one thing, when did the course actually start? From January.
No, no,
November
November,
of
November.
last
Yes,
year. And first semester examination is starting from the 5th of August.
5th of
And you
August.
joined in May and you want to sit in the examination.
Yes, why I joined in May? I joined in May because what happened is after the November admissions were done, there was a matter filed before this honorable court by some.
Whatever the reason, by attending classes only from May till June, July,
Yes.
3 months, you want to sit in the examination.
No, I don't. I don't want to sit in the examination without complete the requisite number of days. That is my specific submission before your ladyship.
Yes.
My submission is that this admission process in the month of May of 2026 was initiated by the university. And Milord and your ladyship, I got admitted in the colleges by the efforts of the university only. The university knows this.
So you take the examination in the next semester.
So I will lose one semester then.
You took admission late. What is this university? Does this university
I'll tell you. May I?
This is my lord half submission made by.
May I-
Let me clarify the situation.
May I?
There was a please. There was a matter.
Let me finish up with
Okay,
the
very
petitioner.
good. Let him show.
Also,
Your ladyship, this is the judgment and order. What happened was many seats across all colleges were laying vacant.
yes.
Therefore, it was permitted as a mop-up procedure to fill up the
Yes.
vacancies. After this notice was issued. So there was a direction also that students who are admitted pursuant to extension will be given additional and extra classes by the colleges in terms of NCT guidelines and fulfill all requisites to enable such students to sit for the semester examination. So I stand to attend all those classes so that my 100 classes are actually achieved by me before I sit for the examination, and that is the duty of the college and the university. The university very well knows that when it admits students in the month of May late, by no flick of imagination can all 100 classes be given to them by the August, where the university has sought to hold the examinations. I only say that I want to go for the examinations only after I am afforded the opportunity of taking all the 100 days of classes. That is all.
Does these colleges function, Mr. Bhattacharya? These are all sham colleges. Only paperwork. No education imparted.
Kindly takes up page 33.
I'll come. Starting from B.Ed to the pharmacy to all these things. Nursing, yes.
Second round admission. The problem is second round, fourth round admission.
Nobody is there. They want money. These are all self-financed institutes. They only want money. Why is the government permitting all these? See, what is going to happen to the students? They are paying. They are not studying. They are paying money. And now,
Observation in lordship order so that we can.
and not only this, now these students, they are collecting the money and paying it, and without a job, they are all on the streets.
An agitation.
That is the only thing that they are doing. And this should be stopped. Yes.
But the issue is that a matter was filed before this Honorable High Court for my lord extension of the admission process. Now, my lord, in
filed
that
it?
order, in
Who
that,
filed it?
my lord, the colleges. The
Colleges.
colleges, not the university.
Yes,
Now, my lord,
yes.
in that matter, the
Ah.
Honorable Court was specifically directed that the colleges should give extra classes because it was placed before that Honorable Court, that coordinate bench, but that it is not possible to give them 100 days class. That is why a special paragraph has been added that the students so admitted pursuant to the extension will be given additional and extra classes by the colleges in terms of NCT guidelines and fulfill all requisites to enable such students to sit for the semester examination. Now, my lord, these petitioners are, my lord, probably making self-destructing submissions. Today, if they say that, and the college has given a intimation to the university that they have given extra classes and these students have attended those classes. Today, if they themselves say that we have not completed 100 days classes, they will be debarred. There is no problem from the university itself. They will be debarred because this is not possible to give them 100 days classes. That is why the Honorable Court makes that provision that you give extra classes. Now, my lord, the college says I have given. The university have concurred with all the colleges held a meeting. So they said, yes, we have given extra classes. Now, if they themselves say, then my lord, these students have to be withdrawn. Otherwise, because other students, they have completed 100 days class. My lord, kindly see the communication from the college to the university.
See one thing. 100 days classes, a student should also be given an opportunity to grasp what is being taught. It is not that it's a bag and you just fill it up.
I completely appreciate, my lord, but what has happened, my lord?
What is this? 1 year academic year means 1 academic year. It doesn't mean you finish up 1 year's course in 3 months and you
6 months course.
Assuming it is a hypothetical submission that the court is making, that if the course is for 6 months, you cannot expect the student to grasp everything within 6 days. It is not possible.
I completely appreciate, my lord, but we have opposed that prayer. It is the court who has directed us, my lord. It is the honorable court's order which we have complied with this particular, my lord, paragraph caution.
Are you aware whether this college is actually functioning?
I tell you,
are you aware how many students are there? Are there teachers? Are there students? Yes.
Every year, when the renewal is given, we, my lord, take data from the students, and there are, my lord, several cross-check methods. That is, my lord, first direct bank transfer. 16 students they require. If they, my lord, do not transfer the money directly to the teachers.
You all are only considered with money.
No, my lord, not that. We say that there are several, my lord, check and balances, and we take steps whenever we receive information that this college is not functioning.
Who is going to give you this information?
My lord, we send, my lord, teams to inspect, and my lord, I tell you, lord,
who are there in the teams?
My lord, from government officials,
government officials,
and my lord, what I have gathered, my lord, after this new government, my lord, they are, my lord, randomly inspecting the colleges.
New government has come in only for 2 months. You are functioning for prior there too.
Whenever we deaffiliate colleges, there are number of matters where, my lord, will see that there are number of matters where, my lord, we deaffiliated. They come to court and for affiliation, my lord. We do this. It's a continuous process, my lord. We inspect. If we find anything, we deaffiliate. There are, my lord, we find in coming days dispute between trustees. We are deaffiliating everybody.
That is a different dispute. A management dispute is something else. But here you are playing with the fate of the students.
Whenever there is anything which is, my lord, affecting the learning process, we divide that college.
Yes, college.
Lordship may kindly comes to page 41.
Did these students attend 100 days?
They have attended extra classes.
But not 100 days. It cannot be.
No.
Yes.
They need some more time to complete because there are 2 parts.
Do y'all give opportunity to these students to appear in the semester examination with the next semester?
Yes, but in that case, the difficulty would be the nomenclature of the examination will be supplementary examination.
Yes, I understand.
That would be the difficulty, my lord.
No, but then since they did not appear in the examination, how come the supplementary will come in?
But because if they appear in the next semester,
find out some other nomenclature. I remember this taking up these matters.
Pass one order.
Examination.
May I?
Yes, some other nomenclature has to come. Because see, you cannot play with the career of these students.
Kindly takes up page 41.
Yes.
And the university today is laying the entire blame on the colleges, but kindly see the conduct of the university.
I understand. Both are in just hand and gloves.
And the session was supposed to begin
in November.
In July.
July.
And that is in terms of the order passed by the Honorable Supreme Court in Ma Vaishno Devi's judgment.
Then?
They don't follow it.
And it comes up to, you say, in November. Now it is in May. The mop-up.
And the colleges approached this court, this honorable court, for filling up the vacancies in the month of February. The order was passed possibly in the month of March. They takes up the entire period OpenSea portal in May 26. 18th May. The classes starts from 25th.
And y'all are also so very hungry that these seats are lying vacant. You cannot function.
And the only source of income from these colleges to give salaries to all my staffs and faculty is from the admission, my lord.
Yes. So only for the teachers, you need money, and the students, let them go to hell.
Probably not the money.
Absolutely, yes.
only one thing, my lord, when the students took admission, they were also knew that this is the situation, because they were aware of
Everybody
the
is
course problem, my lord.
shifting the blame
No, my lord,
one to the
we have
other. The
taken
college
care,
to
my
the university,
We have-
university to the college,
we have
and
already passed
college to the
resolution that
student,
for the next
university to
session,
the
my lord,
student.
there will be because, my lord, we oppose that prayer that do not allow this fourth round of admission, my lord.
And did not prefer any appeal to that.
That is a different issue, my lord.
That is the main issue.
When they
May I
took the
suggest a
admission,
way out with your ladyship's leave? May I suggest a way out which possibly will be beneficial for everybody, even the students who have taken admission before me? The NCT guidelines, I stand to be corrected by my learned friend also over here, says that the academic session for B.Ed, and I have annexed papers also, for B.Ed semester 2 for students who have already completed the required number of 100 days, etc., can begin before the examination also. So if I can humbly suggest this, that let the examination which is scheduled to be held in early August be shifted so as to accommodate 100 days completion by us. In the meantime, if it is anybody's case that they will be losing out on days of semester in the second semester, let the second semester classes be started subject to my passing, or everybody is passing this, and that is guided.
2,000 students, seats are allocated, examination centers are ready, my lord. We are going to question papers are all set for 2 students who are themselves saying that we, for whatever reason they could not have failed, we will stall the entire process, my lord. Is this a practical solution, my lord?
Yes, and the university is aware to all of this. Now let me show this now. Since the university is so much very vocal about these things, passing on the buck to everybody else, let me show from the documents annexed to the petition itself that the university was aware.
But then under any circumstances, the court will not permit you to sit in the examination which is scheduled on and
Even
from
I don't
15th of
want to
August.
sit in that examination.
Not.
I because
Let the examination continue
yes,
as it is, and thereafter we'll see what is to be done.
But in the meantime,
And
I will
college authority, you see how to accommodate these candidates so that you can take examination at a later date, and by giving some other nomenclature so that they also do not miss.
Only one difficulty, my lord. Then the stand of the student is not also correct. Yesterday they filled up the form, and today they are before your lordship. By filling up the form, they have given, my lord, they have attempted. Now the students will be shown that attempted and failed. So, my lord, they should not have, had they been so morally correct, they should not have filled up the form. Today they have filled up the form, my lord.
You do not raise your voice.
No, my lord, I'm not raising, my lord.
Don't.
My lord, kindly.
Don't.
before your leadership passes any further
No,
order,
sorry,
may I
I am not at all inclined to pass any order in favor of the students right now.
Yes.
And I'm going to take serious action against the university as well as the college.
Before your leadership passes any order, just one single page for your leadership's consideration. Page 33 once.
Yes.
This is of 30th of June 2026. Following the notice issued by so-and-so and all the self-finance colleges who have filled up their vacancies for B.Ed course session 25-27 under the BSAEU are hereby requested to email the current status of those admitted students who took admission through the online admission portal of this university with respect to the tentative periods for those students becoming eligible to sit for B.Ed semester 1 examinations and subsequent B.Ed second semester examinations. In this regard, those self-finance colleges are also requested to provide the undertaking regarding fulfillment of NCT norms as asked in the aforesaid notice of so-and-so. So the university knew, and the page previous to that, the university says that those who have completed 100 days can go on to start classes of semester 2 examination.
Is NCT appearing? No.
My lord, I seek indulgence to appear online, lordship. Lordship,
Tell me one thing, does NCT conduct any inspection or anything of that sort? You all call
my lord,
for the records.
My lord, if lordship directs, they will certainly do. But before granting recognition, it is done mandatorily to get the clear picture of the holding of the assets and the libraries and everything. But after the recognition, lordship, it is not routine for the NCT.
Right. Now, the what type of at the time of recognition, what exactly do you all do? Do you all visit? Does your team visit the institutes? They check up whether their students, their classes are held, or anything of that sort. Only the
Lordship,
paperwork you all look at.
No, lordship, there is a team of dedicated professors and personnel. They visit the site. but checking up about the classes is not possible practically, because at that time recognition is pending and classes are supposed to be not held before the recognition and affiliation.
But thereafter, after granting recognition, you do not take any steps.
Lordship, it is for the affiliating body to look after the procedural aspect, and they have to give annual appraisal report to NCT, Lordship. Whether this institute is proper in complying with the formalities, if Lordship directs, I can ask the authority to check and give all the details before
Please
Lordship.
come. This instant writ petition has been filed by 2 petitioners. Who are students. The respondent number 7, Kobiguru Nobel Centenary Training College. In the course B.Ed, within bracket session 2025-27.
Too late now.
Under the Baba Saheb Ambedkar Education University. Stop. The students got themselves admitted in the said course. In the mop-up round which was conducted to fill up the vacant seats of the B.Ed self-financed colleges. In May 2026. Paragraph, the petitioners, in response to the notice published by the university on 25th July 2026, filled up the examination forms and paid the examination fees for the B.Ed first semester regular.
These are contrary to our instruction and submissions of the university.
Examination for the session 2025-27. Stop. The theory external examinations are due to be conducted from 5th August 26 to 11th August 26. Paragraph. For the purpose of attending the examination, the candidate has to attend mandatory 100 days of classes. Stop. As the petitioners took admission in end May 2026, naturally, they could not have attended the mandatory 100 days classes. Stop. Paragraph, submission of the petitioners is that the examination ought to be postponed to allow the candidates to take 100 days classes, and thereafter the examination ought to proceed. Stop. Paragraph. It has been submitted that both the college and the university were aware about the admission of the students in end May, and accordingly, the first semester examination ought not to have been held prior to allowing the candidate to complete 100 days of mandatory classes. Stop paragraph. Learned advocate representing the college submits that additional classes were provided to these students. However, 100 days classes could not be given. Stop. Learned advocate representing the university submits that till the candidate attends 100 days mandatory classes, which is the responsibility of the college, these students cannot be permitted to appear in the examination. Stop. There is, Pradeep, there is hardly any scope to postpone the examination at the instance of only 2 students who have approached the court. Stop. According to the university, the students were aware that they would not be in a position to complete 100 days classes, and they would not be able to take the first semester examination. Stop paragraph. Upon hearing the submission, on a query from the court, a learned advocate representing NCTE submits that the colleges that the colleges are required to obtain recognition from NCTE prior to initiation of the course. Step. It has also been submitted that regular inspection is not conducted. Stop paragraph. Upon hearing the submission made on behalf of all the parties, it appears that the academic session for the B.Ed course starts from which month you said?
July.
July.
In our state, it starts from November or December. Their curriculum says July.
For the month of from the month of July every year. Stuff. In this state, it has been submitted that the course starts from the month of November each year. Stuff. It appears that the candidates took admission in end May of the following year. End May of the following year. Stop. The same implies that the candidate have practically missed more than 75% of the academic session. Stop. The paragraph the notice of the university, which was published on 13th of May 2026, clearly mentions that the online admission will reopen only for filling up the vacant seats of the B.Ed self-financed colleges. Stop paragraph. According to the colleges, if the students are not admitted, then the college will not be in a position to pay the salary of the teachers. Stop paragraph. It appears that the college is only concerned with their finances. Stop. The colleges hardly take care of the academic career of the students who are paying for getting admission in these self-financed colleges. Stop. It is highly doubtful with regard to the standard of education which the student will obtain from the self-financed colleges, which hardly take classes, and the students do not get the opportunity to attend minimum number of days in an academic session. Stop. Paragraph. A course is designed in a particular manner, considering an entire academic year or a semester. Stop. It cannot be expected that a student will grasp the education which is imparted over a period of 100 days within such short span of time. Stop. The same results in improper education being imparted, comma, if at all, which results in students possessing degrees but are left without any jobs. Stop. The same adds up to the unemployment of the students, resulting in frustration and agitations among the students. Stop. Paragraph. The court is of the opinion that the higher education department of the state and the National Council for Teacher Education ought to keep regular checks over the self-financed colleges to ascertain as to whether education is at all imparted in these colleges or they are merely for the purpose of generation of revenue. Stop. The Secretary Higher Education Department is directed to constitute a special team consisting of competent officers to investigate and ascertain with regard to the functioning of the self-financed B.Ed colleges in the state. Stop. The NCTE is also directed to constitute a separate team and physically inspect each and every self-financed B.Ed colleges in the state to find out with the manner and mode of their functioning. Stop. Paragraph. A report by the Department of Higher Education and NCTE shall be placed before this court on the adjourned date. Stop. Paragraph. As regards the petitioners in the instant case, comma, the court is not inclined to pass any order permitting the students to appear in the first semester examination as they did not complete the 100 days classes. Stop. Paragraph. The college is directed to come up with the manner in which how the college intends to accommodate these students who were not in a position to attend 100 days classes. So that they can appear in the first semester examination at a subsequent date. Stop. Release the matter for further consideration on October 2026. Stop.
1st October, 2nd October.
Okay.
The colleges are directed to cooperate with the Higher Education Department and NCTE at the time of conducting the investigation process.
May I, in the meantime, pray for continuation of those supplemental classes for us so that we do not lose our time?
Yes, who is stopping you? Are they not permitting you?
My semester will be over on the conduct of examinations.
Yes.
And then I may be denied immediately. That's saying that your semester's examination are over, so we will not give any classes to you, or you may not be able to continue with the semester one. That is first. And second is my special examination, which your ladyship is contemplating. I bow down to that. In fact, I wanted that only. That only after qualifying I should appear for the examination. That may entail in the similar problem in part 2, unless that examination is given very recently by September or so.
That I cannot say.
That is a long shot, I understand, but in the meantime, supplementary classes.
The college shall, however, permit the petitioners to attend the classes, attend the first semester classes, so that they may be able to appear in the appear in the first semester examination at a scheduled date that may be fixed by the college authority.
And
how you are going to accommodate
difficulty in extending the classes at the university?
by the university, at a college, by the university.
At this,
yes,
my lord is then directing us to held special examination for these 2 students, my lord.
I do not know. There may be 20 also.
Lord, there are no
how many other colleges are there?
But my lord, there is.
You are the. This is not the sole college.
12,000 students took admission in that 4th round of.
Then 12,000 students.
In all the colleges.
All the colleges. So these 2 are not the only one.
All will take examination, which is going to start from 5th, because my lord, they all have.
Without attending 100 days classes. That means you all will permit.
My lord, that is not my submission. My submission is, my lord has perhaps recorded that I have submitted that it is my submission. They cannot attend the first semester examination. That is not at all my submission.
Oh, you say that they can attend with 50 days classes?
I cannot. Not my submission is that since there was a specific order from the court that they have to do special classes, and in the notification which my lord has referred, it also states that you have to attend special classes so that you can fulfill the 100 days criteria.
That means what? 3 classes one day?
Extra hours.
Yes, exactly. That means 3 classes in a day. Extra hours. We have got 24 hours. It cannot be extended to 48.
No, 75 days they have got. And my lord, they can attend extra classes Sundays, Saturdays. This can be accommodated. My lord, those students have said that we have attended the special extra classes, my lord. So my lord, that was not my submission. That has gone down wrongly, my lord.
All right, I'll see what is to be done.
Last one thing, your ladyship kindly takes a look at 9 so that I am not prejudiced. This is the NCT regulations, which permit
promotion to the next semester. Students will automatically be promoted to the next and subsequent semester immediately after completion of one semester course. Yes.
I may be allowed to do this because I do not know when they will come up with the examination.
Yes.
They may come up with the examination. They start courses of July in November.
Yes.
They may come up
second semester.
After my classes of first semester, I may be allowed to take the second semester classes, irrespective of when they allow the examination to be held.
Then this says so. You will be promoted.
They will say that you can do this only when you take the examination. That is
provided he
that
or
is
she
going
has
to be
appeared in the preceding semester examination or filled up the form for that particular semester. or filled up the form for that particular, you'll fall in that fill up form. Suppose even
For
if you
that
have not,
particular examination, they will now distinguish this examination of August with the examination of the special examination,
you
which is
come
going
up,
to be.
if anything happens with the college, because the college is supporting you, you are paying money to the colleges.
Only one thing needs to go down.
We are by ourselves now.
These two students have specific instruction that these two students has also filled up their form.
They have to, because
I have mentioned that they have filled up the forms.
At the very beginning of the order.
Absolutely beginning. I started off with that they have filled up the forms. Please, Mr. Bhattacharya, you have followed what is the concern of the students. Please do. And Ms. Gudgutia also.
Lordship.
Please see that these students can be saved. A future generation is to be saved.
Lordship, Lordship.
Yes, next.
Great, Lordship.
Five.
Malad, in earlier two occasions, your lordship directed to serve the notice to the landed government leader, Malad, who are appearing, Malad, on 27th and 29th, two occasions I serve notice.
Nobody is appearing.
Malad, Sneha Chatterjee.
See if she is outside or not. Yes, our phone number is mentioned over here. Just call. Please call. I'm passing it over.
Malad, in earlier occasion, your lordship also, Malad, specific order has been, Malad, given that if the state respondent will not appear.
What is your prayer?
Malad, my compassionate appointment has been rejected only on the ground that my family income is higher than my when Group D employee.
Yes. So if it is higher, so what can the court do?
No, my lord. This is the only, my lord, order passed by the district inspector of school, and your lordship directed me to any judgment in this regard, my lord. My lord, this is the latest judgment in the 2024. Our coordinate bench, my lord, passed this order that only on that ground that cannot be. My lord, kindly see the judgment.
Give.
And my lord, this is this judgment has been passed
family
after,
pension.
after Reliance, my lord, this Supreme Court judgment.
Yes.
My lord, 2025, our coordinate bench passed this order. But specific, that circular has been, my lord, rejected that prayer.
Which circular?
My lord, that circular is page 45.
Page
They are
45?
saying page 45.
697?
Notification number 697.
697?
Yes,
Set aside?
Yes, set aside.
In this judgment, Shubhrajyoti
this
Mandal?
Yes.
Which portion?
My lord, portion, page 6, 8, 10. That is reliant. And lastly, serial number 14.
Serial number 14.
14 is the
impugned order set
relevant.
aside. Where is the mention of this circular?
Circular mention, that is.
Yes, 697.
Second page.
697.
Second page. And in that judgment, my lord, several Supreme Court judgment has been relied. My lord, only one, my lord, I.
Yes, Balbir Kaur is there.
And no appeal has been preferred against this order.
Just wait. Just wait. It'll pass over, Rahul.
She is coming.
All right, let her come. Next. 16.
For the substitution application has been filed. Can application. Here, the petitioner died on 18th October 2025. Now his wife is the legal heir.
Petitioner died on
18 October 2025.
18th October 25. When has the application been filed? November. What is the time period within which a substitution application is required to be filed?
Within 90 days.
Within 90 days. All right.
Affidavit filed on 20.
And who are the heirs?
His wife.
Nobody else?
Nobody.
The person doesn't have children?
And only for wife, because wife has filed the substitution application.
When somebody dies, he or she may have, may not have. He is a married man. He may or may not have children. Does this person have children? Not aware.
Not lost.
Inquire from your father.
Only for wife is the legal year. She is getting family pension.
She is getting family pension.
Yes,
But
ma'am.
then the others, if the children is there, then the children are required to be impleted as parties.
Because of wife is getting family pension.
Yes, full share family pension the wife is getting.
Yes, ma'am.
Now, what is the prayer?
My prayer is only for entitled the wife family pension, and she is entitled to substitution application.
What is your prayer in the writ petition? Interest on the delayed payment.
Yes, my lord. Yes, my lord. CPF to GPF interest on delay payment, and that matter also before the division bench. And Lord is only for praying for substitution application allow. This is my humble prayer.
Substitution allowed.
I'm grateful, my lord. And matter
Department to make the necessary amendments in the cause title. And as the issue involved in the writ petition is pending consideration before the honorable division bench, let the matter be delisted.
Yes,
Eta written order hobe.
I'm grateful, my lord.
It's item number 7 and 8 with regard to the recruitment of constables. Lordship
Yes.
was hearing this matter the last Friday. I had drawn your lordship's kind attention to the writ petition.
Is it a hearing matter?
Yes.
Why has it come up here? Urgent motion opor dike diye diyechen to puro list aটকে
Take up in the next half or something.
obviously, otherwise
It will take some time.
the end
Yes,
list
I
will
understand.
get blocked.
I had also expressed that the motions will be
দুটোর সময় 7-8 দুটোর সময়
কবে 7
2 o'clock. 7, 8, 9 also? No, 9 is separate.
There are several matters on the line. I don't know.
Yes, which are the other
I
matters?
don't know. Mr. Shamim's matter, I don't know the numbers. I don't know the particulars. Kindly keeps it at 2:30 because I am engaged in before my 2 courses.
All right. There are other matters in the list also.
I think
There possibly from 2 p.m. those matters are there. So
Item number
12.
all right, then it will continue and your matter will follow. No issues. Yes, 9.
My lord, I'm for the petitioner being led by Mr. Sudipto Dasgupta, my lord. I pray for a short pass over, my lord. My senior is engaged in the matter before courtroom number 14, my lord.
So let me see what is the order passed. The sub-inspector.
On 17, your lordship personal order.
Who are you representing?
Directed to submit a report.
Yes.
Yes, report to the report in form of affidavit has been submitting before your
My lord, I'm also submitting my exception, my lord.
What is happening to the students of the school now?
My lord, I'm not briefed in this matter, my lord. My senior can appraise your lordship, my lord. A short pass over may be granted, my lord.
My lord, after the rule right to children to free and compulsory education, rules 2012, you know, this school cannot be done. Because, my lord, they are not
Yes,
conforming
Mr.
with the
Bhattacharya.
norms.
Just wait.
My lord, the basic question remains, my lord, what is the jurisdiction and what is the prior intimation to us that this is going to be remedied by you immediately? We have filed an opposition to the report filed by the state. Their reporting is also, my lord, not based on fact.
Not based on facts.
No. Kindly see, my
What
lord, my
about
opposition.
the unsafe condition of the students they were in?
My lord, absolutely, my lord, this is a wrong perception. The students have been there. There is no question of, my lord, insecurity of the students. We take the responsibility.
No, you cannot take responsibility. The state is definitely there to take the responsibility.
The state,
Parents, Paris, no, it cannot be done.
The state, my lord, has not pointed out that what are the deficiencies which requires to be remedied. But this is not a state-aided institution. This is a private institution. You have the private responsibility. Kindly takes up the report filed by them.
Yes, the report.
My
চেষ্টা করছি
learned jurists are there, my lord. They will.
Yes,
they
yes, it is there.
Yes. Now kindly takes up my exception to the report.
Yes.
Hey, report টা press করে দাও.
Yes, yes, it is there.
Therefore, kindly see, my lord, that the report which is not genuine, that will be apparent from my exception, because school is being run within the 2 floors. And having sufficient space, we have sufficient fire extinguishing arrangement. Nothing has been gone into by them. And there is no such factory which they call it.
You have yourself annexed photographs.
Yes.
To show that there is a gems and jewelry shop over there.
Shop is not creating fire hazard. Jewelry shop, lordship knows of my own personal experience, this does not create any insecurity.
Page 15, the workers are working.
They work at the assembling the jewelry, what should I say?
What does the report say? Does the report specify what are the?
Yes, doesn't. According to me, it does not.
There is none. All right, then please wait. Let us hear what the respondents have to say.
Yes. Lordship, kindly comes to page 6, paragraph 4. Page 6, paragraph 4.
Of what?
Of their petition.
Of their petition.
Petition.
Yes.
The school is situated in first floor of a commercial G+3 storied building in the name and style of Messrs. J.S. Fancy Market, situated at Damjur, P.S. Damjur, Moja Damjur, so and so.
Yes.
My lord, this is not a suitable place to run a school. Under the, my lord, the right to children, right to free and compulsory education, 2012 rules, your lordship says where the school can be run.
কমার্শিয়াল প্লেসেসে চালাচ্ছে কমার্শিয়াল প্লেসে
Lordship, kindly have a look to rule 10. I'm handing up to your lordship the rule 10. Without conforming to the terms of the rule, the school cannot run.
But those are all with regard to the government aided schools.
Now rule 10 of rule
দেখি বই দেখুন তো এডুকেশন ম্যানুয়ালটা আমাদের রয়েছে না এই বইটা কি নীলটা
not only the gold melting, my lord, workshop is running on the ground floor. They have suppressed this fact.
দেখুন তো পেজ নাম্বার 1258 পেজ নাম্বার 1258 আচ্ছা ঠিক আছে রাখুন every school seeking recognition, but this is not a recognized school.
Not recognized.
Then
not applied as yet.
For recognition.
Problem.
My problem is this, my lord. If they not, my lord, apply for the recognition or affiliation.
Can you force somebody to apply for recognition?
Yes. Because this is the right to children to free and compulsory education rules. That has to be complied with.
Can you force?
My lord, the standard that has been prescribed by this rule, they have to follow.
What rule?
Lordship says this rule. I am handing up to Lordship.
What does this rule say?
Rule 15.
What does it say?
Rule 15.
What does it say?
Where the school should be established, how the school should be managed.
You do not recognize. It's as easy as this. The school is functioning without recognition.
No.
What no?
Cannot function.
Where is the bar? Show me the bar.
The rule says bar.
Where? Which rule?
This rule.
Sorry, sir, you are not. You are not answering the query of the court, and you are absolutely going in a wrong direction.
I have told my lord, your lordship, I already told my lord, they are running the school in a my lord
Commercial.
commercial place.
Where is this bar? Show me that the school cannot run from a commercial place. You show me that bar. Show me that bar.
Sub rule 15 of rule, I mean, yes, কোথায় গেল?
What is happening to the students now?
No, we are accommodating them running online classes, which is becoming more expensive for the students. The guardian, the students, they are not willing to go to any other school. I don't think the guardians are so lackadaisical that they are not concerned about the security of the students, of their wards. This is because of an external influence done by some interested party. This is very unfortunate. I am compelled to say so.
Let them file affidavit to that extent.
For the purpose of running a school, you are required to obtain an NOC from the district inspector of schools. Where is that?
I don't require NOC unless I seek for affiliation. NOC by the other, they call it this missionary schools, for which NOC is required, not for all schools. My lord, can you keep it next week? I shall go and explain appearing physically.
Is it possible whether the school should be run
without
the affiliation, without the
You can't provide. The government should
without
have
the
wide
support of the
open mouth.
government anywhere?
Show me the law.
No, I'm showing to the Allah.
Acha, report in the form of affidavit filed by the District Inspector of Schools, Secondary Education, Howrah, and the exception thereto filed by the petitioner in court today be written with the records. Stop. List the matter next Friday.
My lord.
ওইটা বলুন section 12 capital A and 80G of the Income Tax Act.
Yes.
Item number 5, my learned friend come.
Just 1 minute. After 11, I'll come back to you. 10.
My lord, I appear on behalf of the petitioners, my lord. My lord, I have received instructions to withdraw this writ petition, my lord.
This was a case on the last occasion. The lordship asked me whether answer key is still
Yes, it's a doctored one.
Yes, I can. There are 4 booklet codes, 50, 60, 70, 80. So this was 80,
80
and it's still available. I've got a laptop and I can show it to your lordship. Everything, I mean, it is available through it. It's in the public domain.
Now this school, the NTA will obtain an order to proceed against you.
My lord, I have.
And the answer key
Acha,
is
learned advocate for the petitioner relies upon a communication made by the petitioner to the learned advocate expressing her intention not to proceed with the writ petition any further. Stop. In view of the above, the writ petition stands dismissed as not pressed. Stop. Dismissal of the writ petition will, however, not stand in the way of the respondents to take steps against the petitioner in accordance with law.
Kindly record my submission that the answer key is a
Yes.
forged one.
It is recorded in the earlier order. Very first submission, specific submission,
Oh, lordship. I'm sorry.
denies.
Yes. No.
Oh, no.
That.
Yes, specific submission of the authorities that the answer key relied upon by the petition is a doctored one. Paragraph number 2. Paragraph 2 of the last order, 28.
I was looking at this earlier order. Deeply obliged.
So it is already recorded. Next. 11.
Lord, I'm for the petition. Well, on the last occasion that I had submitted my case, but I need to clarify 2 things. One, my lord, is that it was argued by my learned senior colleague that, my lord, the answer sheet was published in the portal and was there in the portal between the challenge period 13 to 15. Lordship remembers the email that my client had received. Now, my lord, I am drawing lordship attention to page 41 of the writ petition. It's already annexed. Page 41 of the writ petition, that is a public notice issued by the NTA itself. In the very public notice, NTA has categorically said that the result was published on 16th of July. If the result was published on 16th of July, the answer key could not have been in the portal prior to that. And it is also records that the individual candidate will receive has received email. That is the email that I
Just
read.
wait. Yes, sir.
The original answer key is my preamble.
My lord, this answer key was displayed. Answer key and answer keys and OMR sheet were displayed from 13th to 15th. And there was a sufficient notice given to all students as per the public notice. So now it was available, very much available. So they could have, if they had any grievance, they could have raised the grievance at that time. Now kindly comes to Lordship, kindly 45. They have received their OMR sheet. NTA published a notice on so regarding display of so 13th, ending date challenge. Then para 2, NTA mailed the OMR sheet on 15 July 26 at 10 p.m. to our registered mail ID. This is what they are saying.
That is the scan
Now,
copy.
now, my lord, let them show their email ID.
Yes, I am not only that.
Yes.
After the last day's hearing, they had sent me another email. The NT had sent me another email after last day's hearing.
This I am not.
Of course, your client has sent it, my lord.
What is?
It's NT has sent me another email after the last day's hearing.
Give a copy to
Yes,
your learned.
kindly see that.
What does it say?
That it says, with reference to your representation, it is to inform that as per the evaluation of OMR sheet, you have scored as such and such. Your actual scorecard has been published in the website and also emailed to you. Kindly note that the tempering of your document has result in such and such.
Yes.
Matter is sub judice. The scan copy was mailed to me. I have referred to that document. I've annexed the email along with the scan copy. That is the same scan copy that my learned senior colleague was referring to the placing before this honorable court. My only prayer today and also on last occasion is, please give me the original mark sheet, because no carbon copy was made available this time, first time. Last year, till last year, they had the proposition of a carbon copy.
What does original mark sheet mean?
I'll show you, Lordship. Lordship kindly takes my email. Not mark sheet, the OMR sheet. OMR sheet. Lordship would kindly come to the email that I had relied upon last occasion. It's annexed to my writ petition at page 25. Kindly read from 24. 24 is
yes.
Email that is a mark sheet. OMR sheet is annexed with a scan copy. Now the original can't be annexed to the email. It has to be a scan copy. So that is the scan copy at page 25. Now Lordship would find in Lordship's copy. It's a colored copy, I believe. Lordship would find from the color copy, the handwriting of the candidate is available. And only allegation is that the OMR sheet has been altered. This was observed by the Honorable Supreme Court in the last year's, when the last year's UG NEET happened, the entire issue before the Honorable High Court. The detailed judgment was passed where it was observed that yes, there is a possibility, I am carrying that judgment, of tampering of OMR sheet. My apprehension.
Till you can show that there is any mens rea, the court is not going to accept your submission that the NTA is going to tamper your mark sheet.
No, I understand that. So
no use making those.
May I make one request? The carbon copy was not given to me. Admit card was taken by them. Everything they have, they admit it in their public notice.
There is no provision of a carbon copy. Then how can the carbon copy be given?
No, not given. I'm saying not given. So I have no mechanism to show what did I answer.
Well, so you have to accept what they say.
So I am saying kindly give me the original. I can tally it with the.
Kindly see the notice.
So only that will resolve the issue.
It is clearly
if
mentioned.
the original is given to me, that will resolve the entire issue.
It is mentioned.
But there is no bar in the
They were supposed to, my lord, keep a watch. I mean, yes. Kindly see.
It is annexed to the writ petition. I have annexed it to the writ petition.
Yes.
It's annexed.
They have been asked to, my lord, they have been.
Page 26 of my writ petition. It is the same document. 13th July. This is my cause of action.
Yes, 13th July.
13th July notification says challenge period is 13th, between 13th and 15th. 15th, 11 a.m. in the morning it expires. I received the OMR sheet scan copy at the night of 15th. They published the result according to them. They published the result on 16th. If they published the result on 16th, they could not have uploaded the OMR sheets or published the result beforehand. It is their own document, page 45. I have shown you, Lordship. 41.
It was uploaded on 13th. There is no dispute.
Right,
There is no dispute with regard to that.
1 minute. Tell me one thing.
In addition to that,
kindly read this page 26.
There is
the
already
41.
a request from the petitioner under the Right to Information Act.
I have annexed it, Milord.
Please reply and
now
whatever the petitioner feels like, we'll take it up later on.
My only prayer in that is also the original OMR sheet.
See, under the RTI, you cannot get the original OMR. So it's impossible.
But there are orders of other courts. I don't want to. Every court is now asking them to produce the original. I am carrying many orders of this year's NEET UG.
Last year,
the court is saying that you give the original, then everything will be refolded.
A student was, my lord, he had approached this court to approach and
May I get a
was
copy?
passed.
Yeah, am I a
to-
candidate?
Oh, my lord, I'm sorry.
একটা copy দিয়ে দিন।
Yes.
Yes.
And ultimately it was withdrawn.
You-
Law director came from Delhi with the original, then
একই তো দিচ্ছেন।
This is some other candidate, not me.
the other candidate.
But if the candidate is satisfied, kindly see the kindly appreciate. This is in my favor. The OMR sheet was directed to be produced in court. In that matter also. So that's my sole prayer. Kindly give the my original copy. I have a right to check.
Subject to the expenses being paid.
That matter, if Lordship feels that a student has to pay that money to see his original answer sheet, I will pay. I will be bound by the order of court. I am saying that.
Lord,
If Lordship feels that a student has to pay this amount of money to see his original, her own original mark sheet, the answer sheet, then he has to pay. She has to pay.
My lord, may I submit this?
But
My lord,
the apprehension is this. I have made it clear.
All the students, I'm from the morning, I'm seeing these matters.
All these students, there's a difference, stark difference. All of them,
Stop it.
all of them have relied upon a separate mark sheet, which my
Yes.
candidate has not.
The cost of repetition, I was submitting that this was uploaded on 13th. From 13th to 15th, it was available.
No,
Now-
the submission of the petitioner is that it was not available.
No, that
How
is
is
not
that?
correct. All 20 lakh students received,
Yes.
and he says that he has not received.
Page 41. Kindly read page.
This was said, it is automated.
Kindly
It is
come
automated.
to kindly come to page 41. Kindly come to page 41. It is his document. I am showing it from there.
In 45, they have admitted it was sent to 2 mails. That means
All scan copy original can't be sent by mail.
no.
Original can't be
Original,
sent by. Kindly
see,
come to page
You
41.
do not press for the original. You have to rely upon the scanned
Then how-
copy.
If I'm saying that that I did not put my pen on that particular answer, if it is the positive case of the petitioner that the petitioner has not marked that answer. That's the case, Milord.
Assuming how many marks short are you from
But
the
according to my calculation, my candidate is supposed to have 600 above, and she has got only 149 or something.
so assuming you get 149,
Yes.
you are not going to reach the cutoff or whatever is the
46, 146.
146, yes.
whatever.
Yes.
So you cannot reach the cutoff by where you can get an admission to a medical college.
The cutoff
Then
is
what is the use?
no use is. I'm not talking about only one question. There are many questions which I have not attended, has been shown as attended, which I have
Sorry,
not
sir.
answered. But those are my pleadings in the petition.
Maybe your
Lordship has to.
the court-
Yes, must be
the
some
court is
mechanism
not
to challenge it.
inclined
Kindly
to
come to page.
pass. No, sorry.
Lordship, kindly come to page 41 for my satisfaction once again.
It is your satisfaction. Keep it to you.
But kindly
The
for
court
page
is
40.
here.
But my client Milord has not given any forged document to court or to them. That's the case in all
Your
other matters. Milord.
submission
Yes, Milord.
that the OMR was not available.
Yes.
This is not accepted by the authority.
I am showing it from
It is
their
an
document.
automated one and it goes to 20 lakh of students.
Yes.
How can it not be
But I
given?
am showing it from their document, page 41. It is their document, Milord. Page 41, kindly see. Milord, may I read the first 3 paragraphs? The national agency has in accordance with prescribed uploaded the website provisional answer keys, the recorded responses and scanned images of each image, and has also individually emailed to every registered candidate a scanned copy of his or her OMR sheet and
You must be having the communication to show that you mailed the scanned copy to this candidate.
Yes,
I am
they
saying
are
I have
admitting.
received email.
There
There is no dispute on that.
There is no dispute.
I have
Now, my
received the
case is-
scanned copy. I'm saying I have said in it petition.
What is the use? You want to see the original? No.
That is the only prayer I'm making,
There
Milord.
is no case made out. Please come.
Milord, my lordship will not appreciate
The
the.
petitioner participated in NEET within bracket UG 2026.
The lordship will kindly record that the challenge period was not available
The-
because they did not give it in time. That's my prayer.
He secured 100. How much? 146.
146.
146 marks.
And he claims
Stop.
650.
According to the petitioner, he ought to have been awarded 650 marks.
Around 26. Around. Milord.
Around 650 marks. ঠিক আছে? Prayer has been made to produce the original OMR sheet. Stop. The scanned OMR of the petitioner was duly forwarded in the registered email ID of the petitioner. Stop paragraph. The petitioner is unable to make out any case for which a direction is required to be passed upon NTA for production of the original OMR. Stop paragraph. Specific stand of NTA is that the scanned OMR is sent to all the registered email IDs of the examinees. Is sent to the registered email ID of the examinees. Stop paragraph.
And it was available on the website also.
The same was available on the website of the authority on and from 13th July 26 till 15th July 2026 within bracket 11 AM. Stop paragraph. In view of the above, the prayer of the petitioner for a direction upon the authority for production of original OMR cannot be accepted. The writ petition fails and is hereby dismissed.
Lordship will kindly record my, Lordship will kindly make one program for RTI. RTI is pending.
রেসপন্ডেন্টের বক্তব্যটা উপরে দিয়ে দেবেন, দিয়ে তারপর কোর্টের এটা দেবেন. Yes.
RTI application is pending. If Lordship permits, my lord,
Yes.
that liberty, that direction may be granted.
The application made by the petitioner under the Right to Information Act is
May I submit? It's not clear to whom it was sent. Or Vishwajit Kumar. See, it should have been sent normally it is should be sent to the SPIU. It is not there.
But he is the
This
SPI.
is not a form.
He is the
Simply they have
SPI.
mentioned.
It's a layman's application, my lord, for RTI, my lord, form. For RTI, my lord.
absolutely there
For
is
RTI, my lord, section 6 permits.
absolutely there is a
Section 6 permits.
procedure.
But section 6 permits
Acha,
layman
ki
to do
bollo?
it, my lord, without the form.
RTI Act is alleged to be has alleged not to have been answered by the authority. Stop. On a perusal of the said application, it appears that the same is not in the proper form and not addressed to the competent authority. Stop paragraph. In view of the above, no direction can be passed upon the authority to act on the application made under the RTI Act.
Lordship.
Lordship, then kindly at least give me the liberty to, my lord, renew that prayer of RTI, my lord. At least that much, my lord. Otherwise, my lord,
What renew?
the RTI, my lord,
Make application. Who's stopping you?
because they will say you have already applied once and these
Certainly not. This cannot be acted upon.
No, give me liberty to, my lord, apply afresh. That liberty Lordship can give me.
No.
Lordship.
Yes.
Gratefully.
Passover matter.
My lord, I am happy.
Are you there?
Yes, my lord.
Please try to make yourself available when matters are called on.
My
Nobody is there,
My lord.
and the court has to direct the petitioner to phone the learned advocate.
My lord, I was engaged in 14, my lord.
Please remain engaged, no problem, but somebody should be here when the matter is taken up for consideration. If next time nobody appears, caustic remarks will be passed, I tell you. Yes. Are you aware what the matter is?
My lord.
Yes, what is your submission?
Sought for instruction from South Chobbish Pargona DI. But they asked for 1 week accommodation. my
Have you gone through the brief?
Yes, my lord.
What is the matter about?
My lord, there was the instruction passed by DI South Chobbish Pargona and
What is the matter about? Where is your brief?
I am not carrying the brief, my lord.
You are not there in the matter.
I am in this matter, my lord. Brief is not with me.
What do you mean to say you are there in the matter and the brief is not with you? What is this type of submission? Huh? How will you appear in a matter if you do not have the brief? You have just been impaneled. There are so many matters where you are appearing. Will you not keep the brief with you? Huh? How will you answer? This matter is pending for the last 10 years. And this relates to appointment on compassionate ground. This is not fun. Please come.
Malat, another judgment, Malat, I am That is 2024.
The
or how it is.
petitioner challenges the order of the District Inspector of Schools within brackets Secondary Education South 24 Parganas dated 22nd July 2016, rejecting the petitioner's prayer for grant of compassionate appointment on the ground that the monthly family income of the petitioner is greater than the income of a Group D staff at the material point of time. Paragraph. For the purpose of arriving at the aforesaid conclusion, comma, the District Inspector of Schools has relied upon Schedule 5 of School Education Department's notification number 697, page 45, please take down, dated 9th of July 2009. The expression within single quotes financial hardship is mentioned therein. Learned advocate representing the petitioner has relied upon a judgment delivered by this court on 28th of October 2025 in WPA 23428 of 2018 with Can 1 and Can 2 of 2021, Shubhrojyoti Mondal versus State of West Bengal and others, wherein the court took into consideration the aforesaid schedule and was of the opinion that family pension should not be taken into account when assessing the financial condition of the family for compassionate appointment. Now, in Shubhrojyoti within brackets Supra, the court also took note of the judgment passed by the Honorable Supreme Court in Balbir Kaur and another versus Steel Authority of India and others, reported in 2006 SEC 493, wherein the court held that family benefit scheme cannot be in any way equated with the benefit of compassionate appointment. Stuff. Paragraph the court in Shubhrojyoti also took note of the judgment passed by this court in the matter of State of West Bengal versus Bina Debnath, reported in 2009 to CLJ 512, which held that the purpose of compassionate appointment is to provide immediate relief to families in genuine financial distress and not to consider statutory benefits like family pension as income. Paragraph. In the instant case, the DI has rejected the prayer of the petitioner for grant of compassionate appointment, only relying upon the monthly family income of the petitioner upon calculation of the pension received by the mother who receives pension, mother of the petitioner. Step. If the pension is deducted from the family income that has been calculated, then the income of the family will fall far below the income of a Group D staff of the state government. Stop paragraph. Next, in view of the above, the reasoning given by the District Inspector of Schools for rejecting the case of the petitioner for providing appointment on compassionate ground cannot be accepted by the court. Stop. The impugned order passed by the District Inspector of Schools dated 22nd July 2016 accordingly stands set aside. Stop paragraph. The District Inspector of Schools within bracket SE South 24 Parganas is directed to revisit the issue all over again and take a decision on the petitioner's prayer for grant of compassionate appointment strictly in accordance with law at the earliest, but positively within a period of 4 weeks from the date of communication of this order. Stop. If the petitioner satisfies the condition for grant of compassionate appointment, then necessary consequential steps shall be taken without any further delay. Disposed.
My lord, if your lordship kindly see for a moment the earlier order passed by this Honorable High Court, page 42, there was a specific direction given by this Honorable High Court that, my lord, District Inspector, page 42, my lord, for a once.
Yes.
My lord, considering the submission advanced by the learned advocates appearing for the respective parties and pursuing the record, I am of the view that the justice will be served if the respondent number 3, the District Inspector of School, South 24 Pargana, is directed to accord approval in accordance with law in respect of the petitioner's appointment on compensation ground within a such and such.
To direct to accord approval of the appointment. Where is the appointment?
My lord, that was the order passed.
Without an order of appointment, how can the approval be given?
My lord, that was not done. My lord, DI strictly rejected.
Yes. Acha. The District Inspector of Schools shall keep in mind that the petitioner's father died in harness way back on 18th December 2012. And immediately thereafter, the application for compassionate appointment was made. Stop. The DI shall strictly abide by the timeline as mentioned herein above and not delay in considering the prayer of the petitioner. Disposed. You take back this.
Correct.
My lord, if your lordship takes up the transfer matters, I need to inform something to your lordship that the portal was opened, but presently it has collapsed. It is not functioning. And these are.
It will open soon.
No, my lord, it is open. I'm not saying it is not open. Kindly see, it is full of error. It is not functioning properly. My lord, kindly see the Honorable Division Bench has been informed about this issue. The Honorable Division Bench necessarily passed order. It to kindly Devan Jocha.
What has the Division Bench?
Division Bench has allowed offline application. Even till yesterday, the Coordinate Bench is allowing offline application. And even in Jalpaiguri Circuit Bench also, my lord, because the portal is not functional properly. There are several errors.
Try to understand one thing.
Yes.
It is only if the portal is functional that these things can go on fast. Otherwise, this problem will remain. In the portal, within 2 days, 3 days, you get a response.
It's not happening. We cannot even apply. That is the difficulty. Kindly see what is happening. Transactional errors.
All right.
And everything.
Transfer matters will not be taken up today. I'll rise
Kindly take the
immediately.
offline.
I'll rise immediately. Transfer nemona.
Your lordship is not taking the transfer matter.
No.
Good.
Let it become functional. Otherwise, what is the use? Passing orders for offline, then again online will start functional, and then these candidates will fall in problem.
No, those matters which are already filed, my lord, the division bench is allowed, my lord, the court bench.
Go to the division bench.
No, I'm not saying this thing.
Go.
No, my lord.
Then
It's that
these
because
matters are pending for years.
yes, my lord. This can be, my lord, disposed of.
When the court tries to accommodate,
Yes, yes.
if barriers are created, then it becomes problem in functioning.
Yes.
So let the system function properly, and then only the next step can be taken up. Otherwise, it will become very difficult.
Some matters already in the portal for consideration. Those matters can be disposed of. It is pending before the SSC in our matters.
It
The portal is not properly functioning.
And my lord, since it is not sent back to the
it will not take much time to cover up whatever is there. It will be done soon.
see the schools. We do not get to see the schools. Nothing, my lord. My lord, that is the old thing is still there. There is no development, my lord.
Sir, a system is there.
Yes.
It has to be followed. It has to be updated. It has to be regularized. Something has to be done.
Yes.
You pass orders. See, still I have got at least 30 minutes time.
Yes, my lord, can you dispose?
At least 30 matters can be disposed of.
Yes, 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 yes.
Why am I restraining myself? Because this is going to create problems.
My lord, they're adhering to these offline directions, my lord. Kindly.
Daily list is 7. Hearing stage ছিল 12টা ডাকুন দেখি 12.
My lord, may I be allowed to mention the fixed matters, my lord? 7, 8, 12, 13, 14, 15, 16, 17, my lord. My lord, in this matter, my lord, learned GP will appear, my lord. Now my lord, he is engaged in another court. My lord, I pray to fix this matter on next Thursday, my lord.
Certainly not. GP is not going to address now. The petitioners are to address. You all are assisting the GP. Sit down and
Very
take
well,
notes.
very well, my lord.
Yes. Which one is yours?
Ours is 7 and 8.
7 and 8. You all want to start?
No, since Mr. Lyri is on his legs before court 18, well, then Mr. Shamim,
Whoever, anyone which can start.
start, my lord.
Nobody is ready to start. Yes. He's coming. What will the court do?
It will take the short password, my lord.
There is no other matters. The entire list is yours.
Yes.
Then?
Short password may be given, my lord. You can start, my lord. Mr. Lyri will be coming. He's on his legs before court 18, my lord.
At least start so that the senior can come and take over. দেখি ফাইলটা কোন একটাতে আমি নোট নিচ্ছিলাম
The last step. No. Seven.
Item number 7.
দিতে বললে পারো।
But 7 and 8, and thereafter 12 to 17.
Yes, same lot. Which one you all want to start? Because I have started off hearing in one matter.
Yes, my lord. And 7, my lord. You can the lot.
7. তাহলে 7টা দিন।
7টা 8 কোন চন্দন ধারা কোনটা চন্দন ধারা
8 চন্দন ধারা।
Yes. Item number 8, my lord, on the last occasion when your lordship was hearing the matter, your lordship has directed to apprise your lordship on the point of cutoff and the whether the cutoff has been fixed properly or it has been arbitrariness. There has been any arbitrariness, my lord. My lord, our submission is that, my lord,
Take your seat, state councils. Take your seat because this is going to continue.
The point.
Bring one chair from behind. Yes. Sit.
The point of cutoff is very much different from the point of pass marks. What the respondent authority has done is that after the recruitment process has started and after the written examination has been held, they have arbitrarily fixed a pass marks. It is not at all in the nature of cutoff. Cutoff is that when a recruitment process is done, to shorten the list of candidates, eligible candidates, and to find out the candidates who are more meritorious, who have got more marks, they does the process of shortlist where there are excess candidates. My lord, in this matter, my lord, the NVF candidates.
May I take?
Yes.
On the last occasion, our brief interbranch. I had made out the case to that effect that the seats reserved basically for implementation of 15% of horizontal reservation. That is the case. I have shown to your lordships that there were 960 seats in respective category that goes down to 1800 seats. That will be appearing from there. In their affidavit, that is what I wanted to draw your lordship's kind attention. In their affidavit in opposition, they have said that they have requisitioned candidates at the rate of 1:5. but not in respect of horizontal vacancies. That is the stand they have taken. Kindly takes the affidavit in opposition once. And thereafter, I'll draw your lordship's kind attention to the rules. Paragraph 11, page 11. Page 11.
L.
Yes, L.
Hmm.
West Bengal Police Recruitment Board has decided to keep the cutoff score of the candidates to be considered under horizontal category for each vertical category 6.5 marks less than the cutoff score of its normal vertical category for shortlisting them for physical measurement test and physical efficiency test, so that all horizontal category candidates are treated as equal within their vertical category. This is erroneous. I will substantiate that subsequently. But before going there, I should meet your lordship's query. The West Bengal Police Recruitment Board decided to call approximately 5 times of the total vacancy under each vertical category for physical measurement test, physical efficiency test, full stop. Accordingly, the board had fixed cutoff marks of score of your category in such way that its cutoff remained higher than the cutoff score of the other vertical reservations. Then board tried to accommodate one horizontal category candidate under the UR category, said by removing the last selected pure UR category candidate from the list, and so on, keeping his stroke her their cutoff marks in such a way that it remained higher than the other vertical reserve categories. Reason behind was that your horizontal category candidate is firstly a UR category, and the candidate score must be higher than the cutoff score of the other vertical category candidates, but would be lesser than the normal UR category candidates. Less horizontal vacancies of all categories would be differentiated and would not be compartmentalized vacancy. Now, Mala, since they have conducted and done this particular exercise at this stage of inception, that is why I had drawn your lordship's kind attention to Saurabh Jadhav, saying that they have erroneously done this. They should have done in accordance with the Saurabh Jadhav, that is preparation of the merit list first, thereafter go down, pick up the horizontal reservation, and thereafter so on, so forth, as decided by Saurabh Jadhav. On the last occasion, I didn't show your lordship this paragraph, so therefore, it was, my lord, the query of the Honorable Court that whether the exercise of Saurabh Jadhav should be conducted at this first stage itself, or whether it should be conducted subsequently. Why I have submitted that it should be conducted at the first inception? Because they have done this exercise at the inception itself. This may not have been done. They ought to have called 1:5 ratio in respect of all categories, and thereafter that would have been, my lord, illogical. Now kindly comes to the rules. Because admittedly, I am trying to, my lord, substantiate before a lordship also that the following that Manjusri, my lord, all the cases, that if there is any cutoff marks fixed for written examination, it has to be fixed and made known to the candidates that this is the cutoff marks. You have to score these marks to go to the next level, which has not been done. Admittedly, they have done this entire exercise after the examination. That is erroneous. There are judgments, lordship also knows, but prior to that, may I just show the rules? Kindly comes to page 49.
Rules
Method of
49.
Yes,
Where
rules.
do I get that?
Writ petition, page 40.
Petition, page 49.
Yes, yes.
Yes.
Now, last line would be relevant, but still, may I just read out? 5A, written examination. Applicants provisionally considered eligible will be called for written examination. Written examination will be OMR based MCQ. The duration of written examination will be 1 hour. The scheme, syllabus, date, venue, such and such, such and such. I'm skipping over for each incorrect, 1.4 negative. And they're relying upon the board will have the discretion to fix qualifying marks in the written examination for shortlisting candidates for the next stage of selection, that is physical measurement test. Now, my lord, here also it has struck your lordship then that whether we are compromising in merit or not, it has fallen from your lordship. Now, in respect of that, we have to consider also that this recruitment is for constable. So the main efficiency would be the physical efficiencies, measurements, thereafter the my lord, the run in the field, that is PET, and thereafter PMT, PET thereafter. So therefore, in this, the merit has to be judged taking into account the physical efficiency also. If a person, say for instance, is very good in studies, qualified, goes to the physical measurement test and his chest is not in accordance with the rules, or he cannot run the particular period for which the test is given, then what will happen is that, say for instance, 5 candidates qualify on the basis of good academic career.
Merit, written test.
Merit is, I am not saying merit is written test. My contention is physical measurement and physical PET, PMT.
Also merit. All right. So in the written examination, 85
This is
a candidate is very good.
My lord.
A candidate where you are submitting, somebody is very good in the written examination,
Yes,
but fails in the next.
So therefore, that candidate is
out.
So what happens is that I am already out because I have been shortlisted.
Because you could not qualify in the 85 marks.
Yes, shortlisted, not qualification. Now kindly reads on. Requirements of the agency, may I just skip over? C. A limited number of candidates, 1:5 that they have admitted, will be shortlisted on the basis of the marks obtained in the written examination for physical measurement test, which will be qualifying in nature. Kindly see, the first is shortlisting, not qualification in nature. So therefore, point is that they at the outset cannot just take me out of the zone of consideration and out of the field. What they have erroneously done is that they have construed shortlisting as the qualifying criteria, which is in respect of the second criteria. Kindly see, the qualifying in nature word appears in next stage.
No, in the first one also.
No, well, first one, kindly see,
The
board will have the discretion. My lord is reading where, my lord? Board will have the discretion to fix qualifying marks in the written examination for shortlisting. The entire is for shortlisting. When shortlisting is done, when there are several candidates applicable. If I would have understood, they have already taken 1:5, that is 1800 into 5, 9,000. 9,000. Say for instance, they have taken into account 20,000. Then there would be shortlisting, because they have to lower the number of persons and have to come to the 1:5 ratio. So therefore, the PET and PMT can be done in an organized manner. There are no overcrowding. These are the things which are all considered and which they are entitled to consider. At that relevant point of time, shortlisting, yes, but that is not for qualification. Kindly see, otherwise the rule wouldn't have said qualifying. Limited number of candidates will be shortlisted on the basis of the marks obtained in the written examination for physical measurement test, which will be of qualifying in nature. The candidates must meet the minimum physical standards as mentioned below. Chest and all these things which is there. Thereafter, kindly comes to next page, B, physical efficiency test. The candidates who have passed PMT, page 51, will be called for PET, which is also qualifying in nature. Means PET, PMT and PET are qualifying in nature. So I have to go to that level. If I do not qualify, then only I'll be disqualified. But here, by the guise of shortlisting, without following the procedure, because they have followed the procedure, I would have understood that the procedure has merely been followed for shortlisting without application of mine of horizontal reservation and vertical reservation. Why I had drawn your lordship's kind attention to Saurabh Jadhav straightway? Because this was while doing this shortlisting, they had in their mind that shortlisting has to be done for implementing of horizontal reservation, which is contrary to Saurabh Jadhav. But my lord, since your lordship is of the view that first part has to be overcome first, so therefore I'm making this submission. So therefore, PMT and PET are the qualifying. Now, they have erroneously done the shortlisting, and shortlisting also, they have fixed the cutoff marks after the examination. That also I'll try to substantiate before a lordship by authorities, that if they want to, this Manjusri is very much established. Now that has been reiterated, upheld by the 5 judges bench, that law laid down by Manjusri is appropriate law. Now, after this interview comes, and thereafter reservation and all these things. Kindly sees the physical efficiency test, and everything, while saying everything, we have to bear in mind that we are considering a recruitment process not of judicial officers, but of constables, in respect of whom the physical efficiency is the main criteria, in my humble submission. Now kindly sees who are the petitioners before a lordship. The petitioners before a lordship are, my lord, the persons who are already in service. Now, my lord, kindly sees in service and contractual service, NVF and civic volunteers. Now kindly sees Home Guards, NVFs and all these things. Well, I have annexed the Home Guard Act also, where lordship would find that we have taken all the, my lord, training and all these things. Now kindly comes to the cutoff now, which has been published in the notification. It was previously also there. Kindly comes to page 120. Kindly sees with whom we are required to compete. The UR category is 48.50. Now the EC category are fresh candidates, exempted category. We are made to be held equal with the EC category candidates. NVF, Home Guard, ex-servicemen, civic volunteers, village police volunteers, and meritorious sports person, MSP. So meritorious sports person, EC candidates, these are all fresh candidates. They are not doing duty for 18 hours a day. They have time to study. And only for giving this kind of leverage to persons who are there in service, this 15% reservation has been introduced. What is the purpose of 15% reservation? So that persons who are already, who know what can be done, what are the requirements, what are the, my lord, difficulties in the service because of the long service hours and, my lord, the schedule of service. So these reservations are there. Otherwise, there was no point of any voluntary horizontal reservations. So the object of these horizontal reservations are taking into account their service. But we are being made to compete with EC category, MSP category. Same is in respect of the other EWS also, same. Scheduled caste also same. EC category and other categories are also there. So therefore, in all horizontal categories, EC is there. So therefore, we are being made to compete with persons who are fresh, and On what basis? On the basis of a purported shortlisting exercise, and that also upon fixing a cutoff marks which is post examination, which is appearing from their affidavit itself. So 3 points at the outset. First is shortlisting. It is not elimination. There were several candidates. Now what has happened in the last is that point কত percent আমরা পেয়েছি?
0.6%.
Yes. I have given a calculation at page 123, which is the basis. Kindly sees how many numbers have been, my lord, called in respect of the horizontal reserve category candidates, because it's at the outset. Your category seats were 1200. Candidates in the list were 7,000 such and such. Now these persons might again fail in the subsequent process. Your EC seats 1400 something, candidates in the list 1200. Your Home Guard and NVF 690, the figure that I am 960, which I am saying, only 6 candidates. So it is 0.06. But in their affidavit, they are saying in respect of vacancies, they are calling 1:5. 1:5 is only in their affidavit. It is not in the rules. So from their affidavit, I have come to know that there is 1:5 ratio that they have followed. Though it was appearing from the calculations, but it is admitted now that 1:5 is being called. So therefore, while calling 1:5, what prompted them at the outset to take us out of the zone of consideration? That is the arbitrariness. That is the erroneous conception that they have proceeded upon. Now, what is the erroneous conception? They, in their affidavit, have taken a specific stand that for implementing horizontal reservation, we have done this. That is their stand in paragraph L, because otherwise there wouldn't have been. They have not said that for taking away the non-meritorious candidates, we have implemented this. They could have said so. But they have taken a specific stand that for implementing horizontal reservation, this was done and the cutoff marks have been fixed. That is why this is straight away hit by Saurabh Jadhav. Because Saurabh Jadhav, if your lordship wants, I can reiterate again. But prior to that, I'll go to the other pronouncements and thereafter come to Saurabh Jadhav again. Now, my lord, to substantiate, first is Manjushree, which has been reiterated and again.
Prior to going to Manjushree, page 49, you read out written examination.
My lord,
Marks, please come. 1 minute.
Yes.
Page 49, the
Yes.
method of recruitment. Written examination, maximum is 85 marks, right?
Just a minute. Page 49.
49, you read out written examination.
Yes. In bold, I was keeping. Yes.
Written examination is 85.
Yes.
And there they have mentioned that they have a discretion to fix qualifying marks.
For shortlisting.
Any reason they'll fix a qualifying marks. What is the marks for the PMT and PET? No marks?
PMT and PET, no marks. This is kindly, may I just read?
Only to be eligible for PMT and PET, they want some marks to be fixed in the written examination.
PMT is measurement. Kindly see, measure candidates of all categories.
It's measurement, but
Run is next. Run is the most important. Candidates who have passed PMT will be called for PET, which is also qualifying in nature. The criteria of PET are as follows. Male candidates have to complete 1600 meters run within 6 minutes and 30 seconds.
Right.
Female candidates 800 meters within 4 minutes. Third gender such and such. So therefore,
you have to qualify. And then if you are there in the list, then only you go to the interview stage. Otherwise, you don't.
No. My contention is that till this run, it is merit.
It
is merit.
Merit.
So though it has not been said in the affidavit that we have chosen to fix the cutoff marks for ensuring that academically meritorious person are taken in as PMT and PET, I would have understood that they are giving credence to academics in constable. That is not the stand, because they know that that is not the standard. Standard is these tests, because we are seeing constable recruitment. That is why I have said all the other judgments are in respect of judicial service. But it has been said that even if you fix cutoff marks, you have to give it prior to the written examination so that the candidates know. Here, say for instance, there is a negative marking. Say for instance, there is a cutoff marks. Candidate goes and sits in the examination hall. Now, it will be in the mind of the candidate that since there is cutoff marks, he may or may not attempt a question of respect of which he is not sure. It might have happened that I have attended questions by which I have given a wrong answer and 1.4 has been taken away. Or on the other way also, I could have attended a question if I had the cutoff marks in mind, then I would have taken a chance of attending a question which in respect of which I was not sure. But I have left out that question. These are the things which can always go on in the mind of the candidates. That is why the Honorable Supreme Court is of the view that you have to make it, there has to be complete transparency, so that the candidates know prior to entering the examination that what is the goal that they have to achieve. That is Manjusri. So therefore, here my contention would be we have been taken out of the competition at a stage where the competition itself has not begun. The competition will begin after PMT and PET. Till PMT, PET, we have to be there. Otherwise, what is the object of keeping the horizontal reservation? It is reservation at the end of the day. And the object is that, I may be repetitive, object is that persons who are there, bigger object is that there are several contractual staffs in the entire police. In fact, the entire lower strata of the police are being run good, bad, indifferent on taking the service of civic volunteers and the others.
And no extra marks for them.
No, they have to run the same run in spite of being in service, in spite of not being able to practice. The fresh candidates are running every day. They have the time to go to the academies to the field and do their practice. Now, in several states, private institutions have come out who are specially giving training to candidates who want to compete in army, in constables. The persons who are already in service, they are serving. They are doing 18 hours duty. They are always engaged. They cannot even go back to their home every day because they have to stay in the barracks. And very bad service conditions, but point is that they knew before coming to this service that these will be the service conditions. I'm not going into all that. But point is that this is the basis of keeping the horizontal reservation. Now, my lord, kindly comes to Manjusri and thereafter again to Saurabh Jadhav. If my lord, if Lordship is not with me and Lordship is, it is something kindly gives me so that I can at least have the opportunity to.
I will let you know. You place it.
Okay. Now, Manjusri na, Tejpal. My lord, Manjusri has been, my lord, 2025 2 SC, 2000 copy of it. reported judgment দেখাচ্ছি 2025 2SC page 1 কিয়েন্দারকে বল তোদের জন্য একটা SCC
This is Tej Prakash.
Tej
This
Prakash.
is not.
This has reiterated, and my lord, because Roshiv is there, my lord, Roshiv knows
Hmm.
Manjusri was referred, and this is the referred judgment. 5 judges bench,
Hmm.
which has again upheld the Manjusri, saying that Manjusri is good law. Kindly comes to তার আগেও একটা জায়গা আমি মার্ক করেছিলাম, দাঁড়া হিমানি মালহোত্রা করলো, না না kindly comes to the submissions, page 18. I will not trouble your lordship with everything, just the relevant points. Submissions 18, 19.2.
Yes.
Candidates have a right to know before the selection commences the standards to criteria on which they will be assessed, evaluated, so that they could modulate their level of preparedness accordingly. A change in the advertised cutoff marks for eligibility to be placed in the selection list after the game is played may seriously prejudice the candidates on 2 counts. First, the candidates may not put in effort more than required for achieving the advertised cutoff marks. Secondly, the interviewer or the evaluator may unknowingly place the candidates in a non-eligible category while imagining that he has been placed in eligible category. Thus, change in the eligibility cutoff after evaluation is done denies the evaluator an opportunity to modulate the marks for placing the candidate in the category which she in view of the evaluator is entitled to place. Here they have made a submission one step ahead, not only of the candidate but also of the evaluator. Now kindly comes to paragraph 33 at page 24 and at paragraph 34 where K. Manjusri has been quoted, and from K. Manjusri paragraph 33. We may clarify, starting with the word, we may clarify the prescription of minimum marks for any interview is not illegal. We have no doubt that the authority making rules regulating the selection can prescribe by the rules the minimum marks both for written examination interviews, or prescribe marks for written examination but not for interview, or may not prescribe any marks for the either written examination or interview. Where the rules do not prescribe any procedure, the selection committee may also prescribe the minimum marks as stated thereon. But if the selection committee wants to prescribe minimum marks for interview, it should do so before commencement of the selection process. Here it is for interview. And next line, if the selection committee prescribes minimum marks only for the written examination before the commencement of the selection process, it cannot either during the selection process or after the selection process add an additional requirement that the candidate should secure minimum marks in the interview. Now the concept is this prior to interview. Now paragraph 35. The desirable ratio in K. Manjusri is that the criteria for selection is not to be changed after the completion of the selection process, though in absence of rules to contrary, the selection committee may fix minimum marks either for written examination or for the interview purpose of the selection. But if such minimum marks are fixed, it must be done before commencement of the selection process. Here, admittedly, after. So, misconception, error. In this view, such and such, I'm skipping over. Paragraph 43 is the differentiation between K. Manjusri and Marwa, where it was dealt that right to appointment and right to be selected in the select list. May I just place also.
what was the distinction made by the Honorable Supreme Court. On the other hand, in K. Manjushree, the eligibility criteria for placement in the selection list was changed after the interview were held, which was a material bearing on the selection. Thus, Subhash Chandra Merwa dealt with the right to be appointed from the selection list, whereas K. Manjushree dealt with the right to be placed in the selection list. Here we are fighting for our right to be placed in the selection list. Now, kindly comes to paragraph 51. Thus, in our view, the appointing authority, stroke recruiting authority, competent authority, in absence of rules to the contrary, can devise a procedure for selection of a candidate suitable to the post, and while doing so, it may also set benchmarks for different stages of the recruitment process, including written examination and interview. However, if any such benchmark is set, the same should be stipulated before commencement of the recruitment process. But if the extant rules or advertisement inviting the applications empower the competent authority to set benchmarks at different stages of the recruitment process, then such benchmarks may be set at any time before that stage is reached, so that neither the candidate nor the evaluator stroke examiner interviewer is taken by surprise. Here they had the discretion to fix benchmark, that is cutoff marks, but they have not set it before that stage. That stage means, in this case, written examination. So they could have set it, even if they were supposed to set, they could have set it prior to that stage, which they have admittedly not done. So error. Now, next is, may I again cite K. Manjushree, because K. Manjushree has been quoted, not required. That is also copy to Judge Sahib ke dili. Tej Prakash. Na Manjushree dorkar nehi. Roshi wants a copy of the Manjushree.
If you have, then
Yes,
please
yes.
give.
Kindly take. আচ্ছা আচ্ছা ঠিক আছে ওটা mark
Or
করা
in case if you want to place any particular
same
paragraph.
same paragraph has
Same.
been quoted,
All right.
and the subsequent inferences, that is, which has been taught to us, that when
Has
the
been taken care of
yes
in Tej Prakash.
yes, because that is the interpretation that we rely. এটা করে দেন, নাহলে এদিক ওদিক হয়ে যাবে. Now kindly takes up হ্যাঁ না না আগে মঞ্জিত 2003-11 SCC 559. By this, I am trying to substantiate that now, my lord, the facts, this I am citing to substantiate that shortlisting can be done, but shortlisting has to be done to bring down the candidates to the ratio in which the recruiting authority is calling the candidates for interview. That is 1:5 in this case. That is, I am trying to substantiate that shortlisting when is required, that when there are several candidates at that relevant point of time, shortlisting. It is not shortlisting, not for elimination or not for qualification. My lord, may I just start from the line, third line, the main question, placidum D.
Paragraph, which page?
First page, 561.
Yes.
The main question, placidum D from here, my lord. The main question. Lordship has been.
Yes, yes.
The main question for our consideration in this appeal as to whether it was competent for the Punjab Public Service Commission, for short the commission, to resort to screening test with a view to shortlist the number of candidates to bring it to the ratio of 3:5 candidates per vacancy, and further whether keeping in view the efficiency required for service in respect of which selection and appointment was to be made, could a written test be held to fix some minimum cutoff where the process of selection was by interview of eligible candidates belonging to reserve category. This is the factual matrix. Kindly comes to next page. There also the numbers have been given as to how many were SC, how many were general. The brief facts of the case are that the advertised number such and such was issued by the commission for requirement of 500 medical officers in PCMS class 1 in all 303 scheduled caste general for short SC candidates applied. The candidates belonging to the other reserve categories like SC, Balmiki and such also applied. The commission scrutinized the applications and notified to hold a screening test on such and such for the categories of the candidate. So far as SC candidates were concerned, out of 303 applications, 279 appeared at SC general candidates, out of which 59 could clear the test. Well, I don't know what is SC general. SC general would be the vertical, I think, not the horizontal. Yes, at that relevant point of time, yes. Balmiki, yes. Balmiki is horizontal, yes. Now, my lord, kindly sees SC general মানে হচ্ছে UR general আমাদের এখানে যেটা kindly comes to paragraph 7. Paragraph 7, page 565. Now adverting to the point of consideration, it may be observed that so far as the power of function of commission in shortlisting of candidates are concerned, there can be certainly no doubt about it. Say, for example, 10,000 candidates apply for recruitment to 100 posts. It would obviously not be possible to take full tests, examination and interview of such large number of applicants, though eligible. In that event, shortlisting of the candidates by screening out those in respect of whom it would serve no purpose to call them to forward a test may be excluded by adopting the method of screening test. This is very important. It has to be remembered in mind. Say, for instance, the candidate we will not be able to take that candidate. Excess, then shortlisting. Here, candidates are being shortlisted at the outset. Generally speaking, a ratio of 3:5 candidates for one post is normally accepted depending upon the number of seats. Here, we read this ratio as 1:5. Therefore, for 100 posts of selecting body may, in order of merit, take out about first 500 candidates for further test stroke interview. The rest of the candidates would be screened out. No candidate excluded by adopting such a method of shortlisting can raise any grievance whatsoever. So therefore, 1:5 complete, go out. Understood. No grievance, nothing. We wouldn't have also not come. But for such shortlisting as indicated above, it is not necessary to fix any minimum qualifying marks. It is only, say for instance, a recruitment is for 100. You take 1:5, 500 candidates come here, others out. Finish. No marks. Any candidate on the top of the list at number 1 down to 500 would obviously constitute the shortlisted zone of consideration for selection. For the purpose of elaborating it, it may be observed that in case of some cutoff marks are fixed in the name of shortlisting of the candidates and the number of candidates obtaining such minimum marks supposes less than 100. In that event, screening test itself will amount to a selection by excluding those though possess the prescribed qualification and are eligible for consideration, but they would be out of the field of consideration by reason of not crossing the cutoff marks as may be fixed by the recruitment. Perfectly in our case, which is going. So we have been denied. These would first is you should not keep shortlisting cutoff marks. Even if you keep the, what will be the consequences? This would be Oh, citation, sorry. 2003 11 SCC 559. State of Punjab, Manjit Singh. This would not be a case of shortlisting. So cut-off marks should not be shortlisting. In shortlisting, as observed above, any number of candidates required in certain proportion of number of vacancies may be shortlisted in order of merit from serial number 1 to the number of candidates required. In this case, 9,000. So therefore, they have erroneously proceeded on the basis by keeping a cut-off marks. And first is that they ought not to have resorted to shortlisting because there were several candidates available. And while doing so, they have erroneously done so. Now again, mark oh yes. Paragraph 10. As observed earlier, for the purpose of shortlisting, it would not all be necessary to not at all. Kindly come. Yes. As observed earlier, for the purpose of shortlisting, it would not at all be necessary to provide cutoff marks. Any number of given candidate could be taken out from the top of the list up to the number of candidates required in order of merit. For example, there may be a situation where more than the required number of candidates may obtain marks above the cutoff marks. Say, for example, out of 10,000, if 8,000 or 6,000 candidates obtain 45% marks, then all of them may have to be called for further test and interview, etc. It would, in that event, not serve the purpose of shortlisting by this method to obtain a given ratio of candidates and the vacancy available. Here they have gone to next step. Say, for instance, if they fix a mark prior to the examination and more than 1:5 gets that mark. Say for 60,000 they get that mark. For 100, so for that they have to, for 60,000 they have to do the PMT. For 100 vacancies, at the most 500 candidates need to be called. If that is so, any candidate who is otherwise eligible up to 500 position, whatever be the percentage above or below the fixed percentage, would be eligible to be called for further test. Thus, the purpose of shortlisting will be achieved without prescribing any minimum cutoff. That is my point. In the case in hand, it is not for the commission to have fixed any cutoff marks in respect of respective category candidates. Reserve category candidates. The result was eventually been that the candidates otherwise qualified were interviewed. Here we read it as PMT and PET. Stands rejected on the basis of merit say they do not have the up to the mark merit as prescribed by the commission. The selection was by interview of the, in this case, going into the facts, selection was by interview of the eligible candidate. Is certainly the responsible commission to make the selection for efficient persons, such and such. The unsuitable candidates could not be rejected in the selection by interview. It is not the question. Now, Malar, this goes on to Malar, the general facts. So, contention that I am trying to substantiate is that it was not at all necessary for fixing cutoff. Even if they fix cutoff, they ought to have informed the candidates that this is the cutoff, you have to do this prior to the stage, that is Manjushri. And secondly, and thirdly, in view of the fact that they have taken a stand in paragraph L of their opposition that they have done this to implement the horizontal reservation, straight away Saurabh Jadhav will be coming into play. Now again kindly comes to Saurabh Jadhav. Multiply করার দরকার নেই. There are several other judgments, my lord, on the same point, but the words which has appealed to me, I have shown it to your lordship, my lord. There might be other judgments also on the same line. I don't want, and that is not also. Oh, acha, আজকে সকালে. মানে my junior insists, my lord, he has found out this line. এটা হচ্ছে 2004-6 কাগজ দে ও আচ্ছা এটাই দিয়ে দেবো আচ্ছা page 786
page 786, paragraph 28, last line. Yes, this is. This has interpreted Manjit Singh, which I have shown to your lordship, paragraph 28, last line, at page 797. Understanding of the court. Even for the purpose of shortlisting, the commission cannot fix any kind of cutoff marks. Within brackets, State of Punjab, Manjit Singh. That is the understanding of the Honorable Supreme Court of Manjit Singh, which I am trying to substantiate before your lordship. Now, my lord, I would have liked to, my lord, place Saurabh Jadhav in respect of, my lord, the purpose of horizontal reservations and all these things as to why this thing. But, my lord, I don't think I'll be able to.
We still have some time.
Oh, yes, we have time.
23.11.
Yes.
Saurav Jadhav.
20. No, I have shown your lordship only 23.11, the procedure. Now, would your lordship want to, my lord, go through the procedure again, keeping in view this? I think, lordship, may I just, because every time we read, at least in respect of my client,
yes,
every time we read in the conspicuous of one particular facts, the interpretation is different.
Yes,
But
absolutely.
the administrative authorities don't understand. This is only in our judicial forum that we understand all these things. They get agitated if we show things to them. Now, kindly comes to, yes, lordship is there. For the purpose of guidance of state government, we are such and such. Now, in this case, number of posts, we proceed on the basis of 11,749. Social reservation is the vertical reservation. In our case, it is 55%. Open category, it has been considered 10. If 100 has been considered, then it will be 51. I have calculated it. It comes to 6,461. Scheduled caste will be 2,585. Scheduled tribe will be 705, which is 17 here. Socially educated, such and such. Horizontal reservation is 33%, which has been taken into account in the model case which has been considered. In this case, it will be 15%. OC such and such. OC is equal to NVF and Home Guard. 17 post is equal to 960. SC is 360. ST is 120 in our recruitment. These are the figures in our recruitment that I have calculated. First step. This is only because they have said in paragraph L that they have resorted to this procedure for cutoff procedure for effecting horizontal reservation. Now, they should have done this. Draw up the list of at least 100 candidates. Usually list more than 100 candidates prepared so that there is no shortfall of appointees when some candidates do not join after offer. This would be in their case 1:5. Qualified to be selected in order of merit. This list will contain the candidates belonging to all the aforesaid categories. This is the basic merit list. From the aforesaid step 1 list, draw up the list of first 51 candidates to fill up the OC quota, 51, on the basis of merit. This list of 51 candidates may include the candidates belonging to SC, ST, SBT. So therefore, first is the vertical reservation.
That is the pool.
Yes.
From where we are
selecting. Pool is step 1. Second is vertical reservation, constitutional reservation. You take out the SC, you take out such and such. In that, if there are horizontal reservations, then you are not required to do anything. That is step 3. Do a check of horizontal reservation OC quota in the step 2 list of OC category. If there are 17 women, category does not matter. Women quota of 33% is fulfilled. Nothing more to be done. If in merit,
NBF, such and such, those horizontal reservations are enough in number. Nothing has to be done. Finish, full stop. If there is a shortfall of women, say only 10 women are available in step 2 list of OC category, 7 more women have to be added. The way to do this is to first delete the last 7 male candidates of the step 2 list. Because these last 7 candidates, because 7 is in respect of ratio in this case. So delete first 7 candidates, thereafter go down the list of step 1 list after item number 51 and pick up the first 7 women category. Woman category does not matter. So therefore you have to go through an exercise. You have to bear in mind that I have to fill out the 15% horizontal reservation and thereafter do this exercise. We have to go down in the list, find out those persons who are there, NVF, home guards and all these things, and bring them up. That is the procedure. As soon as 7 such women from the step 1 list are found, they are to be brought up and added to step 2 list to make up for the shortfall of 10 women. Now 33% quota of the women is fulfilled. List of OC category is locked. 7-2 list become final. Now again, if you do not find, move to SC. This is in respect of open category, that is general. Because this entire thing is being considered on the basis of own merit criteria. In this own merit as in this own merit যেখান থেকে আসলো কনসেপ্টটা own merit কনসেপ্টটা ফার্স্ট জাজমেন্টটা বলো না রিজার্ভেশনের জাজমেন্টটা ভুলে যাচ্ছি in this one own merit concept. Now step 4, move to SC from the step 1 list. After item number 51, draw up a list of 12 SC candidates, male or female. These 12 would also include all male SC candidates who got deleted from the step 2 list to make up for the shortfall of women. Why? Because these SC candidates had qualified on own merit. They were deleted to accommodate women. So they were deleted from that particular place and now they will find their place in SC category. Because they are meritorious, they cannot be just thrown away. So therefore, these 12 would also include all male, because here, while implementing horizontal, male-female has to be taken into account. In this case, in our case, male-female is not the point. But in this case, since the horizontal reservation was female, so therefore it is being said like this. The analogy has to be applied. These 12 would also include all male SC candidates who got deleted from the step 2 list to make up for the shortfall of women. Do a check for horizontal reservation in step 4 list of SC. If there are 4 SC women, the quota of 33% is complete. Nothing more is to be done. If there is a shortfall of SC women, say only 2 women are available, 2 more women have to be added. The way to do is to first delete the last 2 male candidates of the step 4 list and then go down to the step 1 list after item number 51 and pick the first 2 SC women. As soon as such SC women in step 1 list are found, they are to be brought up and added to the step 4 list of SC to make up for the shortfall of SC women. Now 33% quota of SC women is fulfilled. Lists of SC is to be locked. Step 4 list become final. If 2 SC women cannot be found till the last number in step 1 list, these 2 vacancies are to be filled up by SC main. So therefore you have to do the exercise and thereafter convert the vacancies. In this case, kindly see, keeping this open, paragraph K. They have proceeded on the basis that if you do not find, convert. K. It was clearly informed under column 3E of the information to the applicants that the reservation of vacancies under the exempted category such and such, and sports quota will be horizontal in nature. In case of non-availability of suitable candidates under those horizontal categories, the said vacancies shall be filled up by non-exempted such and such, Petitioners did not object. So contention, their understanding is that if at the first stage, if I do not get, I can convert, which is erroneous. If at all conversion has to be done, it has to be done at this stage, after you have done this exercise. So that is why I have shown Saurabh Jadhav. Their contention, that is the misconception. Because why I am saying so, I do not blame them. Basically, point is that I am doing this recruitment in respect of constables from 2016.
And if you think the constables do not have this brain to handle this, then what is going to happen?
Handle
Why?
which? Handle? This.
Yes, this issue. The constables
We
also.
didn't have the brain. So therefore, it was never argued. And at that relevant point of time, in all our life, there was a thing called SAT, where first day is nothing, second day is reply, 2-3 extension for second days. Even the 2016 selection process is ad of today pending. Same argument, same clients, not same clients, the clients were the persons who were in NVF and all these things. They have lost interest, don't call me anymore. In respect of those matters, I had moved the Honorable Division Bench. The Division Bench presided over by the Honorable Justice Dipankar Datta was of the view that they should publish the merit list. On that day, the order was passed, and it was also observed, since the Learned Advocate General had prayed for time, that next time, this, in view of the fact that that was a Friday and the determination was changing on Monday, the Learned Advocate General had prayed for time. The Honorable Division Bench has observed. I have that order, that we were minded to give this order, but subsequently time has been prayed, so therefore it is being adjourned. In the subsequent stages, order has been passed by the subsequent division bench that it will abide by the result. And that abiding as of today is continuing. Matters are pending before the SAT, nothing. Fact that we are being able to make these submissions is because of the fact that there is no SAT. Otherwise, we wouldn't have been able to make, and we wouldn't have been able to reach this stage, because there wouldn't have been any directions for publication of the list itself. For publication of the list, we would have fought 5 years. And thereafter, after 5 years, if we come to say, it is merely academic. So therefore, nothing to be done. Now, the point that I was trying to make is that they have erroneously proceeded on the basis, and they have done so. That is the contention. All the posts which were there for horizontal category, otherwise this proportion would not have come. Page 123, the seats reserved for UR was 1200. Candidates in the list are 7127. So therefore, they have converted. But conversion ought to have been done after this exercise, which they have very conveniently bypassed. But I will be placing 1 or 2 paragraphs in the next date, my lord, of Saurabh Jadhav, and I'll conclude. There are other matters. I think Mr. Shamim is appearing. He will also, my lord, make submissions. My lord, kindly gives me opportunity to that effect.
Senior counsel representing the petitioners, এটা কিন্তু চন্দন ধারাতে হচ্ছে 8 বইটা ফেরত দিয়ে দিন।
এটা একটা প্রিন্ট আউট।
Continuous argument. A list for further argument next Friday. 7th. Next Friday. Let him continue. Then let us see how our position is. Then next week we can always see. But then since we are continuing, let
In
it
fact, I
continue.
will finish on the next date.
Yes,
He
that's
might be
good.
called upon.
Very well.
Yes,
If you-
Lordship may remember, he will
Then
be
we
appointed.
can adjourn it for
Yes,
the
yes,
next
for
day
him,
so that
yes.
he can start on the next day.
Yes, yes.
Your Lordship, for item number 12, may I file the affidavit of opposition?
Keep it with you. When it is called, you exchange it. You exchange it. But today, then it is all right. Today, order is passed only in respect of Chandan Dhara. All right. But the argument will be the same. So please remain present and take down notes.
না 14 বোধহয় এটা 14 বোধহয়
One of my matter, I find that answer that ever deal with that qualifying mark.
ছেড়ে দে ডিল করেনি তারপরে মেনে নিয়েছে
Item 13, who's there for the state? Where is your affidavit? Did you circulate?
মেনে নিয়েছে কন্ট্রাভার্স আবার কি
Keep it with you. Do not file it, but then circulate. All right. 13 is served. 12 is yours. Affidavit ready? Circulated? All right. 14, affidavit. Who's there in 14? 14 affidavit. Whoever is there, please tell to circulate the affidavit in 14, 15, 16, and 17.
16 17 status circulated.
Which one? 14?
16 17.
Circulated. Yes, circulation has been done. It is said. Please check up. Please check up. 14, nobody I find. 14, circulated. Keep the originals with you. When it will be taken up, then we'll file it.
Oh, my lord.
7, same. Same. 8 নম্বরটাকেই আমরা শুনছি। ঠিক আছে?
Yes, I got it.
হ্যাঁ, all will be together more or less. শুধু 8 এরটাতেই অর্ডার হবে।